Good morning, everyone, and welcome to the Standing Committee on Justice and Human Rights. As we move forward with our meetings on remediation agreements, the Shawcross Doctrine, and the discussions between the Office of the Attorney General and government colleagues related to SNC-Lavalin. This is an important meeting where Canadians will be able to hear answers as to questions that are swirling around. And I want to set out some rules for these meetings. Because of the fact that we want to give people the opportunity to pose questions fairly, and the time limits are set, I want to make sure that people's questions are answered so that witnesses have the right to answer the question, but that witnesses need to be succinct in their answers so as not to take away the time from people on their questions. I will strictly monitor the time limits. I'm usually very flexible as a chair on time, but here we're going to stick with 6 minutes, 6 minutes, 6 minutes so that we give everybody a fair shot to get through the rounds and everybody gets their questions in. Donc, je demanderai à tous les témoins d'être assez succincts.
I would ask all witnesses to provide short answers, and Mr. Fortin, it's really a pleasure to have you with us here today.
A meeting on this subject, we're joined by the Honorable David Lametti, Minister of Justice and Attorney General of Canada. Et nous sommes aussi accompagnés par Madame Nathalie G.
We also have with us Ms. Nathalie G. Drouin, Deputy Minister of Justice and Deputy Attorney General of Canada. We will hear the witnesses. I would ask Mr. Lametti to please begin. I would like to thank the committee for this privileged occasion to speak to you here today. As of the last 2 weeks, after the original publication about the allegations in the Globe and Mail concerning the nature of conversations between the former Minister Wilson Raybould and the Prime Minister's office,
Going to hold. Oh, sorry. Est-ce que ça m'a? Est-ce que?
Testing, 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 testing.
Mais c'est très important d'avoir la traduction.
It's very important to have interpretation in both directions. What I can say is that we don't have a flashing light indicating interpretation.
OK, ça va? Si ça va, ça va.
Good, we're on. Can you hear me? Understand me? Good, very well. With your permission, I'll start again. I would like to thank the committee for this privileged chance to speak to you here today. As of the last 2 weeks, since the initial publication of the allegations in the Globe and Mail regarding the nature of conversations held between the former Minister Wilson Raybould and the Prime Minister's office, events have moved very quickly.
At least in part on anonymous accounts, it has become clear that Canadians deserve and require a public and transparent review of the events at issue. That is why I support the process initiated by this committee. Après tout, l'un des piliers de notre démocratie est...
After all, one of the pillars of our democracy is that Canadians have full confidence in the proper administration of our system of justice and in its oversight. I know that this committee can help ensure that that confidence is upheld. There is no doubt, there is no question, indeed, that the Attorney General of Canada plays an important role in upholding the rule of law in Canada. We must not doubt whatsoever the government's commitment to upholding the role that the Attorney General must play. That said, I would like to take a moment to say a few things about what I may and what I may not discuss here today. Although the facts remain uncertain, those that have come forward so far raise serious questions about the manner in which decisions to initiate prosecutions are made.
With the transparency they deserve, but in such a way that preserves rather than undermines the following: the right to a fair hearing in cases that are currently active, the integrity of the position of the Director of Public Prosecutions, and the rule of law in our country more generally. Furthermore, any responsible review must account for the fact that SNC-Lavalin is currently engaged in 2 legal proceedings involving matters related to the subjects under consideration today. In other words, we must recognize that transparency can only happen if we approach conversations like today and the ones that will follow in a considered and responsible manner. Here's what I can talk about. There are 3 areas that I will be able to speak to today. The 3 areas reflect the 3 topics identified in the motion that this committee passed last week. First, the Shawcross Doctrine, as well as its general implications to the matter at issue. Second, discussions between the Office of the Attorney General and government colleagues. And third, remediation agreements. First, I want to be clear with the committee that while I had a general knowledge of this matter as a Montreal MP, I did not speak with the Prime Minister or any member of his office about it prior to my appointment as Attorney General. Second, I am ready to discuss legal parameters concerning the role of the Attorney General in Canada and how those of us who are granted the honor and responsibility of the position must interact in Cabinet. My view is that while the Attorney General must be able to make decisions independent of partisan considerations or direction, the Attorney General is also not an island. These are not easy decisions that face any Attorney General, and his or her ability to get the answer right on behalf of all Canadians is only improved through discussion and debate with the rest of Cabinet and the experiences and views that they reflect. For the purposes of this committee, it is important to understand what this relationship means in terms of what may or may not be protected by legal privilege. Privileged conversations will only occur between a lawyer and a client when the purpose of the conversations is to seek or give legal advice and the communication is intended to be confidential. In my view, there will be many instances where a conversation between an Attorney General and his or her Cabinet colleagues will not necessarily be in the framework of a solicitor-client relationship and therefore not be protected by this privilege. In particular, the Shawcross Doctrine contemplates that where the Attorney General and not Cabinet is the final decision maker, he or she may consult his Cabinet colleagues. Conversations of this nature are not inherently privileged by solicitor-client privilege. There is a range of opinions in both case law and academic commentary as to what aspects of these conversations might be covered by solicitor-client privilege. Let me be very clear. I am not saying that there should be a rush to a comprehensive waiver of privilege without the benefit of details and regardless of any impact on ongoing legal proceedings, as some on the opposition benches have suggested should be the case. What I am saying, however, is that a policy debate between an Attorney General and a colleague at Cabinet concerning a decision of the Attorney General that the Attorney General must make is not inherently covered by solicitor-client privilege, whatever other protections may apply depending on the facts of the case. Finally, if it remains helpful to this committee, I believe we can discuss remediation agreements in general. It may be helpful for Canadians to understand some of the reasons why Canada has the mechanism in place, why other countries, such as the United States and the United Kingdom, also use them, and how they work in practice. I can also speak to the kinds of circumstances where a remediation agreement might be available. On a related point, I can speak to the legal mechanism that allows the Attorney General, rather than the Director of Public Prosecutions, to assume responsibility for a specific decision on a specific prosecution. On this point, I think it's important to note that the statutory regime is designed to protect the rule of law and shield prosecutorial decision-making by ensuring that any decision on the part of the Attorney General to follow this course of action must be transparent to the Canadian public and include publication in the Canada Gazette. Here's what I cannot talk about. I believe a discussion of those 3 areas will constitute a full response to last week's motion, in addition to an effort to assist the committee in its review of the allegations at issue. However, as I mentioned before, I wish to make clear in advance that there are also certain areas where I believe it would be irresponsible of me to speculate, express an opinion, or otherwise speak to matters that could undermine the conduct of ongoing prosecutions or the institution of the Attorney General. Permettez-moi d'être plus précis.
Allow me to be more precise. First, I will not be able today to speculate on conversations in which I have not participated. I think it's quite relevant that I speak of the fact that the former Attorney General has not issued any directives in the SNC-Lavalin case, nor in the framework of any other specific prosecution, given that nothing has been published in the Canada Gazette. However, I'm not aware of any details of any conversations between her and the Prime Minister and or the Prime Minister's office, other than for what the Prime Minister has made public. Second, as I mentioned already, I will not be able to speak of matters covered by the solicitor-client privilege. As does any attorney, the Attorney General has a legal and ethical duty to protect the confidentiality of communications between attorneys and their clients. For any Attorney General, it becomes all the more essential to respect these obligations when they involve the public interest. Likewise, I will not speak of questions and matters covered by litigation privilege. These are matters which, were they disclosed, would compromise the Director of Public Prosecutions or the government's ability to pursue any legal matter currently underway or being considered. Third, I cannot speak of matters discussed in Cabinet or with my Cabinet colleagues. Canada has a long tradition of protecting the confidentiality of such discussions. Fourth, I cannot speak of any legal case currently before the courts. Such a restriction, normally called a sub judice convention, a convention regarding to matters before the courts, are essential. They protect the constitutional independence of the judicial process in Canada. Thus, I will not be able to answer any question about any matter before the courts. This will include any discussion I have had as an Attorney General on the good sense of proceeding or not proceeding with a remediation agreement with SNC-Lavalin.
Remain a lawyer, which is a profession that I have done my very best to honor for the past 25 years, first as a clerk at the Supreme Court of Canada, then as a professor of law in the law faculty at McGill University. I continue to take these obligations very seriously, and as such, I will do my best to ensure that my answers today are as transparent and candid as they can be, while still making clear to you any obligations of confidentiality that I owe to my client, Canada, that I understand myself to owe. Thank you. I now turn the floor over to my Deputy Minister.
Madame Drouin?
Merci, Monsieur le Ministre. Bon matin.
Ms. Drouin, thank you, Mr. Minister. Good morning, Chair and members of the committee.
He said, it is my goal this morning to be candid and transparent with you and to respond to your questions with as much relevant information as I can. On logistics, please ask me your questions in the official language of your choice, and I will do my best to answer in the same language. However, you may notice that I am more comfortable in my first language, so if I feel that I will be more precise, I will speak in French. J'aimerais commencer par décrire mon...
I would like to begin by describing my dual role as the Deputy Minister of Justice and Deputy Attorney General of Canada. I've been in this position since June 2017. In both these roles, I support the Minister of Justice and Attorney General of Canada in fulfilling his or her responsibilities. My functions include giving legal advice and coordinating the legal advice given by the Department of Justice, supporting the development of legislation and policy that fall within the justice portfolio. Functions implicate a number of principles that Minister Lametti set out for you today and that have been the subject of public commentary.
Deputy Minister and Deputy Attorney General, I am involved in communications that are solicitor-client privilege, where I have also the duty of confidentiality, and where maybe a matter can be considered to be protected by the cabinet confidence. Sometime one, sometime two, sometime all of the three principles will apply to these communications, and sometime none of the principles will apply. Whether the principles apply in a given situation is highly fact-dependent. I would like now to talk about the role and speak a little bit about the Public Prosecution Service of Canada, which is really separate and distinct from the Department of Justice. The Attorney General is supported by the DPP, the Director of Public Prosecution, and please note that the DPP is also a Deputy Attorney General of Canada. The DPP is responsible for initiating and conducting federal criminal prosecution on behalf of the Crown. The DPP's role is separate and distinct from mine. Et bien que la directrice des
While the DPP is responsible for conducting federal criminal prosecutions, I can support and provide legal advice to the Attorney General of Canada in exercising his powers under the Director of Public Prosecutions Act. One recent example is the support the department gave to the Attorney General in regards to the directive related to prosecutions of HIV non-disclosure cases. I have no involvement or role in any prosecution, and in fact, I am not privy to any evidence in regards to prosecutions. That is entirely the DPP's role. In my role as both a public servant and a lawyer, with the support of my department, I strive to provide government decision-makers with all of the professional and nonpartisan advice they need to carry out their duties.
roles as Deputy Minister and Deputy Attorney General, and all the duties and obligations that we just described, I would like the committee's understanding with respect to the information that I will be able to share. Having said that, I am prepared to respond to your question, and I will give you the best answer I can in light of my obligations. Thank you.
Thank you so much to both of you for your comments. So the committee's first round is 6 minutes per questioner, and we're going to start with Mr. Cooper.
Great. Thank you, Mr. Chair. And prior to posing my substantive questions, I would ask that the witnesses be sworn in pursuant to Section 10, Sub 3 of the Parliament of Canada Act.
Mr. Cooper, that would require the committee to concur. We have not done that at this committee. We look back and we haven't done it for 25 years, but I've asked the clerk to explain. We'll stop his time.
Stop my time.
Can you press the button? We'll ask the clerk to explain the difference between a witness being sworn in and not sworn in, because a witness is still bound to tell the truth. Mr. Clerk?
Oui, effectivement, Monsieur le Président, vous avez...
Yes, indeed, Chair, you are correct on this. Whether a witness has been sworn in before a parliamentary committee or has solemnly declared they would tell the truth or not, they must tell the truth when they bear witness before a committee, whether they're sworn in to do so or not. The only thing that a swearing in does, what it changes, is that a committee member having evidence that a witness has lied may report this to the House. And the House might theoretically decided to withdraw the protection under parliamentary privilege, which covers the testimony, and this then might lead to a perjury charge being laid by the Crown. But in 50 years and more, that's never actually occurred. So, Mr. Chair, witnesses are held to tell the truth whether they're sworn in or not. If they are sworn in, of course, there are specific consequences.
Either sworn in or not, the only difference is the charge of perjury if Parliament. Okay, so
That's true.
So the committee is aware. I think in order, Mr. Cooper, to not have, unless you want to have a long debate, can the committee just vote? Would that be okay?
That's fine.
Okay, perfect. So the motion by Mr. Yes, of course. The motion by Mr. Cooper is for the witnesses to be sworn in, and I will ask the clerk to then do a recorded vote. If you're voting yes, you're in favor of the motion of the witnesses to be sworn in. If you're voting no, you're voting against the witnesses being sworn in. Mr. Clerk.
Monsieur Boissonneau?
No.
Mr. Essassi? No. Mr. Fraser?
No.
Ms. Khalid?
No.
Mr. McKinnon?
No.
Mr. Barrett?
Yes.
Mr. Cooper?
Yes.
Ms. Wright?
Yes.
Mr. Rankin?
Yes.
In favor, 4, 4. In défaveur, 5.
Okay. The motion is defeated. Mr. Cooper, you're back on your questions. You are 20 seconds in.
Great. Well, thank you, and I guess the fact that Liberal members voted against having the witnesses sworn in to be here under oath speaks for itself. So I'll start with Mr. Lametti. Thank you for being here. First off, did you discuss your testimony with anyone prior to coming to today's meeting?
I discussed it with my team. Other discussions that I have had would be covered by solicitor-client privilege.
Thank you. Now, I believe I heard you say in your opening statement that prior to being appointed to cabinet, you did not discuss the SNC Lavalin prosecution with the Prime Minister or anyone in the PMO. Is that correct?
That's correct.
Not with Gerald Butts, not with Matthew Bouchard, not with Katie Telford.
That's correct.
Okay, thank you. Now, prior to being appointed to cabinet, during your time as a member of Parliament and as parliamentary secretary, did you meet with SNC Lavalin at any time?
I believe the lobbying record shows that I did meet with SNC Lavalin in May of 2017. I must admit, I have no strong recollection of that meeting. As you know, as Parliamentary Secretary to the Minister of Innovation, I have to interact with people across Canada. I met with people in my office. I met with people across the country.
Okay.
I believe the precise lobbying record shows that the topics they listed were all ISED files, and justice issues were not part of the specific lobby record on my name.
Thank you, Minister. Let me refresh your memory, if I may. The meeting was indeed in May of 2017, May 30th of 2017. According to the lobbyist registry, the topics included government procurement, industry, and infrastructure. Do you recall who you met with?
I believe I met with Neil Bruce, but I don't have a strong recollection of that meeting.
So,
As I had said, I was one of the most heavily lobbied members of Parliament in 2017. As a result of being part of that, I was lobbied by big businesses, small businesses, universities across Canada.
I understand that, Mr. Lametti, but you did meet, in fact, with Neil Bruce, and Neil Bruce, of course, is who? The CEO of SNC Lavalin, correct?
That's correct. That's correct.
So, a pretty big deal. It must jog your memory quite a bit.
Actually, it doesn't jog my memory. As I said, I believe the Hill Times reported that I was the most lobbied MP in 2017, ahead of my minister, Minister Baines, at the time. Now, again, it was part of the role of the Innovation Minister to meet with stakeholders across Canada.
Well, anyhow,
and
I
it is
understand
up
that,
to the
Mr.
lobbyist to list, as the lobbyist has done, the topics that we covered.
Point of order.
Mr. Chair, is it not the convention that the length of the answer matches the length of the question?
That hasn't yet occurred before this committee, but I've asked the witnesses to be considerate to give the people, the members, their time, and I will keep trying to do that, and Mr. Cooper will make sure to get his time.
Okay, well, thank you. And Mr. Lametti, it was noted that one of the topics was government procurement. Of course, that directly concerns the issue at hand in terms of the prosecution of SNC Lavalin and the impact that will have on their ability to bid on government contracts. So let me put it to you simply, did you discuss the fraud and bribery charges involving SNC Lavalin with Mr. Bruce?
Again, I have no strong recollection of the meeting.
But I presume,
as I said, it is up
Mr.
to the
Lametti,
lobbyist to report.
I understand your answer. You say you can't remember. Okay, but I presume you had a staff member with you.
It was my practice to have either my parliamentary secretary assistant at the meeting or a member of my Hill staff. We have been unable yet to ascertain with ISED who the person was staffing me at the meeting. We can get back to you on that. But I can tell you,
I presume, Mr.
that
Lametti,
I can tell you,
yes.
Mr. Cooper, that there wasn't, I recall, any strong action item as a result of that meeting either.
Mr. Lametti, I presume your staff takes notes?
Either the Parliamentary Secretary Association or the staff.
So will you undertake to identify who accompanied you to that meeting and to provide to this committee, table with this committee, any notes taken in respect to that meeting?
I will undertake to find out who staffed me at that meeting, or indeed if the meeting actually existed, because oftentimes, as you know, on the lobbying record, the lobbyists throw in.
Fair enough. Fair enough. Thank you.
But I won't undertake.
You answered my question. You're going to undertake those two things.
No,
So
I
thank you
didn't
for
undertake
that.
those two things. I'm not going to. I'm going to take on advisement whether I can produce those notes or not.
Thank you. Now, Mr. Lametti, immediately following the Globe revelations of these very serious allegations, you were quoted, and I'm quoting from CTV here, quote, but certainly from what I have seen and what the Prime Minister has said, I can reassure Canadians that there has been nothing inappropriate that has happened, unquote. Who told you to say that?
That quote was recorded on the 8th of February, I believe, the day after the revelations broke. At that point in time, we had only unsubstantiated anonymous sources in the Globe and Mail, and we had the Prime Minister's unequivocal denial that any wrongdoing
But
had
you said
happened.
from what you've seen.
That
6
is
minutes.
precisely the answer from what I had seen.
Thank you very much. The next questioner is Mr. Fraser. Mr. Fraser.
Thank you very much, Mr. Chair. Minister, thank you for being here, and Madame de Brouin, thanks for joining us today. Minister Lametti, is it appropriate for the Prime Minister and officials to talk to the Minister of Justice and Attorney General about active cases and prosecutions? And is that an ordinary thing that you would do in your role?
Absolutely. As I said in my opening remarks, the Attorney General can't be an island. That is the whole point of the Shawcross Doctrine, that an Attorney General can speak with Cabinet colleagues about a variety of different considerations that might be pertinent to his or her decision in any particular case. What is clear in the Shawcross Doctrine is that subsequent to those decisions, those discussions, when an Attorney General puts on his or her hat as Attorney General, then only the appropriate considerations that the Attorney General, he or she, himself or herself, has in mind will be the basis for that decision.
And is there any timeline on when that would be inappropriate to have discussions with the Prime Minister or other officials or Cabinet colleagues in the course of a prosecution?
Depends on the timeline of the discussion and the prosecution, but I can't say without any further context what would be appropriate or inappropriate.
Let me ask you this. If the Director of Public Prosecution makes a decision to proceed in a case, and the Attorney General may still have an option to instruct the prosecutor, for example, to enter into negotiations for a remediation agreement, but to do so would require public notice to be made in the Canada Gazette.
Correct.
Would it be appropriate for the Prime Minister and officials to discuss the matter with the Attorney General in contemplating such an instruction to a prosecutor?
I think, once again, the Shawcross Doctrine would apply. So those kinds of conversations would be appropriate to the Attorney General contemplating a decision on whether or not to direct a remediation agreement. But it is up to the Attorney General to make that decision himself or herself.
Minister, have you ever experienced inappropriate pressure being applied by the Prime Minister or anyone in the PMO on the issue of remediation agreements or any other legal issue?
I have not.
Would your expectation of the types of conversations that would occur between either the Prime Minister, Prime Minister's staff, or Cabinet colleagues, would your expectation be that those would be robust conversations in contemplation of the application of both policy and law?
I have stated generally what my understanding of the Shawcross Doctrine is, that there would be conversations that would be possible. I'm going to say that if I elaborate too much on that answer, that could put me into a territory where I'm speculating on what other people might do under similar circumstances. And as a matter of prudence, I think it would be unwise for me to speculate on the kinds of conversations or perceptions that other people might have. I can only speak to what I might do, which is certainly if I felt that I was being directed, I would take under the circumstances a number of different actions, but I won't and shouldn't speculate on what other people might do.
Fair enough. Madame Drouin, if I could just ask you a question. With regard to the role between the Director of Public Prosecutions and your role as Deputy Minister, you had talked about the fact that there was definitely a distinction between the two roles and the two hats that you wear. Can you explain how those roles may interact with regard to any prosecution?
So it's really the DPP who has the discretion, responsibility to take any decision on a specific investigation to decide to lay charges or no. As I said in my opening remarks, I don't have any access, or I'm not aware of any evidence relatively to a specific investigation. But my role is to provide legal advice on any acts, and I can provide legal advice to the Attorney General to make sure that he understands how the DPP Act operates, and also giving him advice if he decides to exercise one of those rights.
Thank you. And Minister Lametti, just going back to the appropriateness of conversations with Cabinet colleagues, I assume that so far in your role as Minister of Justice and Attorney General, you have had some of those conversations, and that would be an ordinary thing that you would do in your role.
Absolutely, it is part of the familiarization, if you will, with the dossiers that I have to work with in my time as Attorney General.
Thank you very much. Those are my questions.
Thank you very much, Mr. Fraser. Mr. Rankin.
Thank you. Welcome, Madam Deputy, Mr. Attorney General. My first question is to you, Mr. Attorney General. Yesterday, in an unprecedented event, the former Attorney General rose in the House of Commons and asked if she could speak her truth. So I'm going to ask you, in light of the fact that in her resignation letter she alluded to the importance of an independent Attorney General in the prosecutorial function, and also alluded to that in another context, I'm going to ask you the simple question, will she be allowed to speak her truth?
We are doing our best. I am doing my best as Attorney General to find a way for that to happen, which does not compromise, which of course provides transparency to Canadians and provides fairness to the former Attorney General, but also does not compromise any of those other matters that I mentioned at the outset. Litigation privilege in particular, because there is ongoing litigation between the Director of Public Prosecutions and the company in question. So, as she has stated, the question of solicitor-client privilege in particular is complex and layered,
Okay, well,
and we're trying to sort through that
Let me ask you
as
about
best
that.
we can.
Let me come to that very issue. And a prominent lawyer from Toronto, Andrew Roman, has written in an influential blog the following. I want to ask if you agree. Quote, no one in government was permitted to give the Attorney General any instructions when she or the Director of Public Prosecutions were involved in a prosecution. As she could not have been under instructions from any client, there cannot have been any solicitor-client relationship, and as such, there can be no solicitor-client privilege. There was no valid reason for either the Prime Minister or his senior staff to initiate any conversation with Jody Wilson-Raybould. The only reason for either of them to discuss her prosecutorial decision would be to encourage her to change it without being seen to do so. This is damaging to the rule of law, close quote. Do you agree?
The question of solicitor-client privilege and the question of whether it applies in any given set of facts, or the question of whether it has been waived in any particular set of circumstances, is part of the general question that I have to answer as Attorney General. And so I can't pronounce on any of that, as you will well know as a lawyer, without compromising solicitor-client privilege myself.
You are a lawyer, I am a lawyer, but it may be that the Attorney General was not a lawyer at the time of the incident. That is to say, we have now learned that she was not a lawyer in the eyes of the legal profession when the decision was made to continue with the prosecution of SNC Lavalin on charges of fraud and corruption. The Dean of Law at the University of Ottawa, Adam Dodek, who wrote a book called Solicitor-Client Privilege, has argued as follows. Under existing doctrine, it is difficult to reach any other conclusion other than legal advice from a non-lawyer Attorney General is not encompassed by solicitor-client privilege because a non-lawyer AG does not qualify as a professional legal advisor. What are your thoughts on that?
I'm going to decline, out of prudence, to give an opinion on that because, once again, it may be part of an opinion that I have to render.
Who is the client? You mentioned that you owe it to your client, Canada, as Attorney General. I want to know if there is solicitor-client privilege, a matter which many lawyers think does not exist in these circumstances. Who is the client? The late Justice Rosenberg of the Ontario Court of Appeal said the client ultimately of the Attorney General is the Queen, and that is because she represents the rule of law. Do you agree with that? And therefore, who gets to waive the privilege in these circumstances if such privilege does exist?
Again, the question of waiving privilege, the client is Canada. The question of waiving privilege, as you well know as a lawyer, is a very complex question in these cases, and once again, that falls under my responsibility to maintain that.
So it's you who
solicitor.
decides. It is you who decides the waiver?
I am saying that it is part of solicitor-client privilege on my part to not be able to answer that question.
So who does?
Again, it's not a question as for the reasons discussed. It's a question that I cannot answer here.
So we may not
Because
have anybody that can waive privilege.
You can invite Professor Dodek, I believe you have, for his opinion. You can invite other experts. You can invite former Justice Rosenberg.
He's deceased.
Oh, that's problematic. That's problematic. You can invite other experts. I am currently the Attorney General for Canada. I am currently, as the Prime Minister has said, advising the Prime Minister on these matters. So I am covered by solicitor-client privilege. I simply
accept
cannot
that.
answer
I accept that. But when we keep hearing about waiver of privilege, if that exists, we never get to know who gets to waive it. Is it the Prime Minister? Who is it?
Again, that is a very complex and layered question.
Layered question, but it seems to go fundamentally to this. Can I ask you a final question?
You will see in the academic literature that there is a dispute.
Yes.
So I cannot pronounce on that.
Can I ask you this? Can I ask you this final question?
Like 45 seconds. So your last question. Yeah.
You mentioned cabinet confidentiality as well. Can it be invoked with respect to conversations between an Attorney General and Prime Minister office officials such as Mr. Butts or others? Does it exist in that context?
Once again, you will know as a lawyer that I have been asked to give a legal opinion. That is an ongoing continuum, as other legal writers have described, solicitor-client privilege, and that is part of the continuum. I simply cannot answer that question.
Mr. Boissonneau.
Thank you very much, Mr. Chair. Minister, thank you for being with us today. You mentioned in your opening remarks the importance of remediation agreements and that we have this framework here in Canada. Could you share with us why a framework of remediation agreements is necessary in Canada and why it was put into law?
Certainly, I can do that. A remediation agreement is another way that criminal behavior, serious criminal behavior, can be prosecuted. It is another tool in the toolkit of our Director of Public Prosecutions to go out and punish serious criminal behavior without endangering innocent third parties, such as employees, such as pensioners, such as third-party contractors and subcontractors who may be working on these various projects, because it doesn't put the viability of the company itself in question, but rather allows those to be prosecuted for the company to pay very serious penalties and for supervision to be imposed on the company so that any corporate criminality as part of its culture can be changed. It's a very important thing. Our allies have it, the United States, the UK, Australia's contemplating it. it is an important element in the arsenal for combating serious fraud internationally.
I think it's very interesting that you mentioned the third parties. I appreciate that. J'ai quelques questions en français. Juste pour
I have a few questions for you in French, just to get back to some of the comments made earlier. When it comes to the SNC-Lavalin file, were you ever led into discussions about this with the PMO office before you were appointed as Attorney General? Before being appointed, no. I do have a general understanding of the situation, given that I am an MP from Montreal. I had a meeting, as has been pointed out, with the company as a lobbyist in 2017, in May, but nothing beyond that. As your current role as Attorney General, have you ever felt an inappropriate level of pressure related to this case? No. Thank you. I have a question now related to something that came up during question period in the House of Commons on Wednesday. Our Conservative colleague, Ms. Wright, asked, and I quote from the Hansard, I would ask the Member of Parliament from Montreal, it so happens, what he knows about the SNC-Lavalin case. What do you think she meant by this? I have no idea, really. I am a proud Montrealer. I am a Montrealer by choice. I chose to reside in Montreal. And in Montreal, at McGill, I was trained in both French and English, common and civil law. I am bilingual. I've lived in Montreal for 30 years now. I've had my children there, and my children have been educated in Montreal. So it is really off the wall to suggest that an MP for Montreal would be incapable of playing the role of the Attorney General in any situation whatsoever, but especially in this case. I find this quite shocking. I'm a proud Montrealer, a proud Quebecer, and a proud Canadian, and I'm most proud of the fact that I live in a very dynamic French city, francophone city such as Montreal. I wasn't able to speak French before I got to the St. John campus. So I congratulate you on that. I am proud to have a francophone from Quebec in the role of Attorney General. I think it's important to ask whether you're aware that the Conservative Party appointed only 3 ministers of justice from Quebec throughout the entire history of the Conservative Party.
Topic.
On remediation agreements,
Yes.
could you expound a little bit more on the kind of third parties that may be affected if remediation agreements were not in place in Canada?
Well, depending on the nature of the company, certainly employees. Let's say in any scenario, the company ceases to exist. Employees lose their jobs. The funds of pensioners become jeopardized, and that's certainly an issue, a policy issue that needs to be taken into account. The third-party suppliers, innocent third-party suppliers who may be selling materials or services to a company, subcontractors, depending on the context of the industry. All of these people are innocent. All of these people did not partake in any kind of criminal behavior. And oftentimes other people in the company. Companies are large, companies can be a large entity in which only a very few people were participating in the kind of criminal activity that would be targeted by a remediation agreement. So it makes sense, as our partners have shown us, the UK and the United States, and it was perceived to be a gap. We had consultations for this particular bill, widespread consultations, including Transparency International and other organizations who came and said, this is the way to go. This provides a very important tool in the toolkit to punish corporate criminality without jeopardizing innocent third parties.
Merci.
Now we're going to go to a second round of questions. In the second round of questions, there is 6 minutes Liberal, 6 minutes Conservative, 6 minutes Liberal, 5 minutes Conservative, 3 minutes NDP. We're starting the second round. Mr. Assassi. Monsieur Fortin?
You We're going to give me some time. Yes, before when we finish the questions, I would ask the committee permission to hear from you, Mr. Fortin. Does that suit you?
Mr. Chair, now, firstly, I'd like to thank you for coming here. I think it's imperative that there be greater clarity with respect to many of the issues that Canadians are concerned about. I will start off with asking you about remediation agreements. You have stated today that when it comes to remediation agreements, there's punishment, there's heavy fines. So what would you say to those people who say remediation agreements do not hold corporations accountable for their wrongdoing?
I think that's patently false. There is a joint admission of guilt in a remediation agreement, a joint statement of facts, in which the guilt is admitted and the behavior guilty behavior is admitted. There is a stay of proceedings, but if the company departs from that, the criminal proceedings can start again. So it is another way of punishing. It is by no means a sweetheart deal or anything like that. Perhaps the deputy would like to add if I've missed anything.
No, I think you had it right. Maybe just to add, the other goal is really to bring compliance in a specific corporation, and saving also innocent victims and third parties. And I would like also to say not only employees, pensioners, but small shareholders also.
Thank you for confirming that. Now, another thing you alluded to is the fact that remediation agreements are legal tools. So why do you call them legal tools? Is it correct that courts would be very much involved in ratifying such agreements?
Yes, you're right. The agreement has to be accepted by the judge. The agreement has to be public too. This is an important aspect. And before concluding a remediation agreement, victims must be consulted.
Would you care to add anything to that? Absolutely. Well, thank you for that, and thank you for confirming that the courts would be involved. Now, if we can move to another issue that is of concern to many, given what we have heard, and this is an issue that you have alluded to. I'm speaking about the Shawcross Doctrine. Now, next week, we will have the opportunity to hear from experts. But as you know, the Shawcross Doctrine fuses together various principles. Can you unpack those principles, the ones that, in your opinion, are relevant?
Well, again, as I said in my opening remarks, the Shawcross principle protects the unique role of the Attorney General to make decisions which are of his or her responsibility. But it also recognizes that the Attorney General is not an island, that there are various kinds of considerations that an Attorney General would be wise to take into account. And as Lord Simon said in the famous quote on Shawcross, an Attorney General might be a fool to not take those into account. So it recognizes that there will be conversations that need to happen on a variety of different issues. Once you take that into account, it is a question that will always have to be answered on the facts. And so speculating further on what is appropriate or inappropriate would be impossible for me to do.
So I understand it. There can be many discussions, but ultimately or eventually the decision is the Attorney General's decision.
That's right. As Lord Shawcross said, it's his in this case. It's his to make. I would say it's his or hers to make.
And you have said that you will refrain from speculating. But in your opinion, is the Shawcross Doctrine and the principles, are they objective or are they subjective?
Well, somewhere the answer is somewhere in between, because the facts will always be, in a sense, subjective in the eye of the beholder. So I'm it's not, there's not a clear answer to that question. Any good lawyer will be able to spin objectivity into subjectivity and vice versa. So I'm not going to do that. But I am going to say that it's a difficult question in each and every case to be resolved on its various facts by the parties who are involved in it.
So you have on several occasions today, you have said the Attorney General is not an island. This is something that I understand you brought up with the Canadian Bar Association last week as well. We know there are complex issues involved, but there are also various responsibilities that you have. Could you guide us and tell us what those distinct obligations are?
30 seconds.
Well, I think what I said to the Canadian Bar Association is quite in line with what I'm saying here today, which is I am open to conversations as Attorney General and a member of Cabinet. When I put on my hat as Attorney General to make a decision as Attorney General, that decision is mine alone.
Thank you very much, Ms. Raitt.
Thank you very much. Madame Drouin, for just a very quick question, I wanted you to confirm for me that the directive that you spoke about that will be published in the Canada Gazette does not need to be published until after the matter is concluded, meaning after the court has agreed to the remediation agreement and everything is final. That's correct. That's Section 11 of the Act, is it not?
I just want to make sure. Are you talking about the directive I was?
A directive from the Attorney General to reverse the decision of the Director of Public Prosecution that's supposed to be published in the Canada Gazette does not need to be published until after the court proceeding has concluded, meaning the court has accepted the remediation agreement. Is that not true?
Well, you have many kind of possibilities. Depends on the nature of the
But is
directive.
that what I stated? Is it true what I stated, that it doesn't have to be
Well,
published
it depends
till
the
after?
nature of the directive. First thing is when an Attorney General decides to issue a directive, he has to consult with the DPP.
So I understand the process, Madame. What I want to know is it not possible that a directive would not be published in the Canada Gazette until after the court had concluded the matter? Is that not possible, according to the Act?
I think I don't provide legal advice to the committee,
Sure.
and
Okay.
you have and like it's so fact dependent. But I think what is important is to understand the steps and also to understand that any directive have to be published in the Gazette of Canada.
I understand. And what I'm trying to tell you, Madame, is the fact that this notice does not have to be published until well after a federal election in 2019.
I'm not sure you can
So,
conclude that because it's
I'm just
really
putting that
fact
on the record
dependent
for
and the nature of the
for my
directive.
purpose.
I'm sorry, the
May I
nature of
ask
the
as well,
directive.
when the Attorney General makes a decision to order or direct the Director of Public Prosecution to do something, he or she is not doing it as the Minister of Justice. Is that true? It's the Attorney General that only has the power to be able to ask the Director of Public Prosecutions or Director to proceed with one of these remediation agreements.
That's certainly my understanding.
That is correct. So
Yeah.
for the entire period of time post September 4th, when the Director of Public Prosecutions made her decision, you could only have conversations with the hat of the Attorney General on your head. You were not the Minister of Justice, or one would not be the Minister of Justice on that topic.
I can't speculate because I wasn't party to any of those conversations.
Well, I think it's appropriate, and I also think that it's also appropriate that we look at the Shawcross principle, as you've pointed out, and the Shawcross principle says very clearly that it's not necessarily to be pressure from the Prime Minister, doesn't have to be subtle, doesn't have to be heavy. Any communication from the Prime Minister to the Attorney General could be perceived as an attempt to influence her decision, improper interference, because she's only the Attorney General. Is that not true?
That is not how I would interpret the Shawcross principle. Attempting to influence is something that you do as an MP, that I do as an MP, that our constituents do to us as MPs. It's part of what we do around the cabinet table.
Sure.
It's what we're part of. So attempting to influence is something
let me
is
break
part
it
of
down
our.
for you.
It's part of the. No, let me answer the question, please.
You have
It's part of the
answered it, sir.
DNA
It's
of
not
our
your
political
opinion.
process. The question in Shawcross, in the quote that you raise, is pressure, and that is a subjective determination. Like, we can't talk about that without knowing the facts.
So, with respect, when acting as the Attorney General and choosing not to direct the Director of Public Prosecutions, SNC Lavalin, in going to lobby the Prime Minister's office or other cabinet ministers, or indeed the Clerk of the Privy Council, is going to those places in order to try and convince the Prime Minister to ask the Attorney General to change her mind. Is that not the case?
I can't speculate on that. I'm not privy to those conversations.
That's
You
not a
should-
conversation.
You
That's
should
not.
know that
That's
as
how
a lawyer.
power. I think that's a fair assumption that one can draw. Don't you think that's a fair assumption one can draw?
I'm not willing to draw any assumptions about conversations.
So only the Attorney General can make the decision. SNC Lavalin decides that they're going to lobby at the highest level in the country. Presumably, it's because they want the Prime Minister to change her mind. Isn't that not? Can we not draw that assumption for the September 17th meeting?
I think I was not privy. I know I was not privy to those conversations, and I think it would be unwise.
Well, one conversation you were
draw
privy
any
to,
kind of,
Mr.
assumptions.
Lametti, was I remember the first time the Prime Minister asked me to be in Cabinet. I'm sure you remember that. It would be a momentous occasion. In that conversation with the Prime Minister, did he mention the issues with respect to SNC Lavalin and the difficulties that he was facing?
He did not.
Can you tell me, Mr. Lametti, whether or not that issue had been shared with you prior to you becoming the Minister of Justice and the Attorney General?
I've already said that.
Can you answer it again for me, please?
I did not. I had a general knowledge. I believe you asked me this in the House of Commons. I had a general knowledge of this as a Montreal MP of the issue.
So, Mr. Lametti, Globe and Mail's reporting that there's a cabinet meeting. I'm not going to ask you about the contents of the cabinet meeting. It's more of a hypothetical. Pretend you're the Attorney General, as you are. You're sitting in a cabinet meeting where a former Attorney General alleges that there was improper influence on her at that time. As the current Attorney General, do you have an obligation to resign?
I am going to rely on cabinet cabinet.
Not asking about what happened, but in order to uphold the justice in the country, do you not have an obligation to resign?
Ms. Wright, the time is exceeded. I'll give Mr. Lemony a chance to answer the question, and then we'll move to the next questioner.
I
Mr.
can't answer that question as a result of cabinet confidentiality, on the basis of cabinet confidentiality.
Thank you very much. Ms. Khalid.
Thank you, Chair, and thank you to our witnesses. Merci, Madame.
Thank you to Ms. Drouin. Thank you for being here with us.
A lot about the Shawcross standard or the Shawcross doctrine, and for Canadians' sake, I mean, I'm hoping that we can, at the very least, help Canadians understand in layman's terms, what is this standard? Is it a complicated one? And when we talk about the interactions, is this and specifically about pressure? Are we talking about an objective standard, or are we talking about a subjective standard? Madame Drouin, if you can answer that for me, please.
Comme le ministre.
As the minister has said, it's a rather difficult question to answer.
Attention of this committee on a case that happened in 2006 and 2008 in UK. It was a very serious case where the director of serious fraud was involved, doing both, responsible both for the investigation and the prosecution, and it was about military procurements. During its investigation, the director got contact from a country and also from the Prime Minister, saying that if the Attorney General continues the investigation and the prosecution, blood can be on the street. So, and finally, the director decided to stop the investigation and not to lay charges. That case created a judicial review, and it went up to the House of Lords. And the House of Lords did say that this very hard and difficult conversation didn't break the rule of law. So that, I think, really illustrates how serious conversation can be.
So just to clarify, it did not break the rule of law.
Did not.
Did not. Thank you very much for that clarification, Madame. Monsieur Lametti, merci for.
Mr. Lametti, thank you.
taught some of our colleagues in the field of law. And I just want to ask you, we've had a lot of conversations about ethics, about character, about the nature of our conduct as members of parliament, as cabinet ministers, and even as prime minister. Can you explain to us and to Canadians what education or training do you have that qualifies you to uphold the ethical obligations of the Minister of Justice and the Attorney General of Canada?
Well, thank you for that question. I've had the good fortune, my parents came to this country with no formal education, and all they wanted for their children to get was a formal education. And it enabled me to get the highest quality legal education in Canada and abroad through scholarships and bursaries. And I have lived my life. I have lived my life in a law faculty. I've had mentors such as Justice Peter Corey of the Supreme Court of Canada, Professor Rod MacDonald, who had the highest ethical standards, and we lived and taught professional ethics. We lived and taught ethics as lawyers on a day-to-day basis. I'm a member of 2 bars of Ontario and Quebec. I have maintained my ethical obligations in those bars, and so I think I'm highly qualified to perform this role.
Perhaps we could have Mr. Lametti take a little less time to answer, and we could get to something more relevant. All members have a right to put their questions in their own time. Hearing something about the background of the witness, that if this is the question, this is the question.
I actually had. Thank you,
Okay,
Mr.
thank you very much. Ms. Khaled, you have 2 minutes and 20 more.
Thank you, and I will reiterate the relevance of my question is that we've had a lot of conversations in our parliament amongst Canadians about what ethics, what standards do we govern ourselves with as Canadians? How do we govern ourselves, and to what standards do we hold ourselves? And I would like to hear from the minister what qualifications, what training he has that qualifies him to be in such a high position, that qualifies him to make the very important decisions that Canadians expect him to make in the right manner. So please, Mr. Lametti, if you can please answer the question.
Well, I have, let me answer this another way. I have conducted my life as a teacher, as a mentor, as a scholar to the highest ethical standards. I have studied the law. I have lived the law, if you will. I have debated the law. I have debated what is right and wrong in the context of one of Canada's and the world's greatest law faculties. That is a privilege that I undertook quite seriously. And let me add that one of the reasons why I got into politics is because the previous government's attacks on the Supreme Court and attacks on the criminal justice system prompted me to say that particular life which I was participating in was insufficient to give back to Canada.
Thank you. If members can please.
I'm asking everybody, when somebody has a question, try to be respectful. If you have a point of order, you make the point of order. Ms. Khaled, you have 45 more seconds.
Thank you, Chair. And I have a very short one. Mr. Lametti, since being appointed as the Attorney General, what conversations, if any, have you had with the former Attorney General?
I have had initial conversations at the very, but not substantive. They were the kinds of pleasantries that one would exchange on the exchange of the position. When the story broke in the Globe and Mail, it was my view that as Attorney General, I should maintain a position that would not compromise me or the Office of Attorney General in any way, shape, or form, in light of the fact that there would be already very quickly afterwards, there was contemplation of committee proceedings, contemplation of an ethics committee investigation. So I felt it necessary to not engage in any conversations on this matter with my predecessor.
Merci. On va passer à Monsieur Paulus, mais je vais...
Very well, over to Mr. Paulus, but I will warn Mr. Paulus when we're at 4 minutes so that Mr. Barrett may speak shortly after. Mr. Paulus. Thank you, Mr. Chair. Ms. Drouin, in your work as Deputy Minister of Justice and Deputy Attorney General of Canada, can you tell me what happened on the 4th of September when the decision to pursue the prosecution against SNC-Lavalin was taken and that SNC-Lavalin was advised of this decision? When was the Prime Minister's office advised of this, before or after? Let me clarify. I am not the Director of Public Prosecutions. I'm the Deputy Minister of Justice and Deputy Attorney General. I have no information about specific cases. So on the 4th of September that you're referring to, I was not given any information, and I know more about it today than I did then. I only know what the public knows. I believe that around October, SNC-Lavalin made a public announcement that the Director of Public Prosecutions had refused or turned down the request for a remediation agreement meeting. But you, as legal advisor of the Attorney General, if I understand that's what you explained, you advise the Attorney General, you must have some interaction with the Public Prosecutions Office. Perhaps I can specify that the Director of Public Prosecutions is responsible for advising the Attorney General of advances in important cases. So from time to time, so on the 4th of December, when public prosecutions told the Attorney General, I'm not aware of that. These communications don't go through the Minister. So I can't tell you who knew what when. These conversations might have occurred, might not have occurred on any specific files between the Director of Public Prosecutions and the Attorney General. When the Prime Minister's office asked Ms. Raybould on the 17th of December to meet, did Ms. Raybould ask you for any legal advice before that meeting? In my role, I have many conversations with ministers, and I support the Minister and the Attorney General in their roles. But, of course, we have been mentioning the privileges, the litigation and solicitor-client privileges, so I can't tell you what advice I may or may not have given. Very well, then. There's a legal privilege that covers these issues, so you can't tell us whether Ms. Raybould asked you for legal advice before meeting anyone on the 17th of September. Yes, that's my response. Same thing with the 5th of September meeting with Mr. Butts at the Chateau Laurier. I can't even tell you whether I was aware or not of any discussions that might have been underway. We do speak regularly. It is my role to equip a minister or attorney general, if I can put it that way, to fulfill their roles. But when I do so, this is under the legal privilege. Thank you, Ms. Drouin. Mr. Lametti, before you were sworn in, and you were sworn in on the 14th of January, before that, did Prime Minister Trudeau discuss the SNC-Lavalin file with you? I've responded to that. No. No discussions. Okay.
The left.
Okay. Mr. Drouin, when did the Director of Public Prosecutions inform PCO, the Privy Council Office, PMO, and the Minister of Justice about the outcome of the deferred prosecution agreement? When did the Prime Minister know?
So, first, there is no direct communication in any specific case between the PMO and the DPP. The obligation of the DPP to report on specific case and to provide information to the Attorney General is really to provide information to the Attorney General as the Attorney General and not the Minister of Justice. And the DPP does that on a regular basis on high-profile cases.
Okay. Mr. Attorney General, both you and the Prime Minister have said that you're preparing a legal opinion on solicitor-client privilege in relation to the former Attorney General, Ms. Wilson-Raybould. Now, lawyers I've consulted with say that solicitor-client privilege is far more limited than your government appears to understand. It applies only to communication between a lawyer and client for the purpose of giving or obtaining legal advice, not every single utterance. So you have the benefit of more than 5,000 employees at the Department of Justice, and they're at your disposal. So it's our understanding that the former Attorney General, Ms. Wilson-Raybould, will appear here on Tuesday. Will your legal opinion be prepared in advance of that meeting?
As the former Attorney General has stated, the question of solicitor-client privilege is complex and layered.
Will it be ready for Tuesday,
Substantial debate.
Minister?
There is substantial
The answer
debate
seems
on
to be
the
no.
extent.
Minister, is that a no?
It is a continuum, and I can't answer the question because the question itself, the answer to the question, is covered by solicitor-client privilege.
Thank you. We're now going to Mr. Rankin. Mr. Rankin, you have 3 minutes now.
I want to start by saying I know you, sir, to be a highly competent and ethical lawyer who I hold in very high regard. In response to my colleague, Ms. Raitt, you said you won't make any assumptions about a particular matter. Yet, on February 10th to CTV, quote, you said this, quote, the Prime Minister has said these allegations about the bombshell Globe and Mail report are false. We haven't had any corroborating evidence there. There hasn't been anything to my mind that justifies a committee to investigate. Now, you, sir, are the arbiter of justice in this country. It seems to a reasonable person that you have already made up your mind that there's nothing here, drive on. So isn't it, having taken the word of the Prime Minister that there was no wrongdoing, how can you discharge your responsibilities now in this matter as an independent arbiter of justice, having, it would appear to Canadians, made up your mind? Is that a reasonable inference?
I disagree with the inference. I disagree with the premise of your question. First of all, the Attorney General is not, unlike other jurisdictions, does not have an investigative role. We delegate that to other kinds of institutions. Secondly, at the time that interview was taped, the 8th of February, it aired the 10th. At the time the interview was taped, all we had were anonymous allegations in the Globe and Mail and an unequivocal denial by the Prime Minister. So at that point, on the 8th of February, I stand by what I say. Now, I also said in an earlier interview that day, with the House, which was taped prior to the CTV interview, but was played before, I also stated in good faith that this committee, was the master of its own docket, and that I would appear if they called me to appear.
Okay.
And Mr. Rankin, I am here.
I hear you, sir. Whether you're answering is another question. I want to put to you these facts. September 4th, the DPP, the Director of Public Prosecution, tells SNC-Lavalin it's a done deal. We're going to go forward with criminal prosecutions. On September 17th, the Prime Minister meets Jody Wilson-Raybould. On December the 5th, Jerry Butts meets with Jody Wilson-Raybould at the Chateau Laurier. In each case about SNC-Lavalin, if the decision of the DPP, that final decision, was made on September the 4th, after the final decision, what properly could have been discussed with the Prime Minister or with Jerry Butts in these circumstances? How can we not reasonably infer that there was an attempt to politically interfere with her role as the independent Attorney General?
Hear, hear.
I can't confirm that any of those meetings...
They're all on the public record.
I can't confirm that any of those meetings took place, let alone speculate about what the content of those meetings might have been.
Oh, right. Thank you.
Thank you very much. So, colleagues, that concludes the second round of questions, but we have a request from Mr. Fortin. The Bloc Québécois is not a recognized party, so the Bloc Québécois does not normally have the right to ask questions at committee. However, Mr. Fortin has asked on an exceptional basis to be allowed that for this meeting. I don't want to create precedents, but for the purposes of this meeting, I'd be willing to accord him 3 minutes. Did the colleagues agree? Okay. Monsieur Fortin, vous avez 3 minutes.
Mr. Fortin, you have 3 minutes. Thank you, Mr. Chair. Mr. Minister, Mr. Lametti, to your mind, does the Attorney General of Canada have the right to require of the Director of Public Prosecutions that they undertake negotiations with SNC-Lavalin to move into a remediation agreement discussion? They have that power. Yes, they have powers under the legislation. And the right answer is that the authorities and powers are specified in the legislation. There are different interpretations now of the legislations, and I will not speak to that today because this might have an effect on litigation privilege and have an impact on ongoing litigation. That's the issue. I understand that. I won't go on given I have little time, but I would just like to know whether this power exists. I will give you no reading on that. I will simply say that the legislation does exist. All right, the legislation exists. It allows the Attorney General to require of the Director of Public Prosecutions that they undertake negotiations around a remediation agreement. I can't give you any advice on how to interpret the law. I can only say that that legislation exists. All right. So if it does exist, can you tell me why this hasn't been done? Why hasn't the Attorney General issued a directive to the Director of Public Prosecutions to undertake a remediation agreement negotiation? I can't speculate. Well, no, it's not a matter of speculation. You are the Attorney General. All right, then I can't answer your question in this case due to litigation privilege. My saying anything, my providing you with an interpretation at this point might impact ongoing litigation involving SNC-Lavalin and the Director of Public Prosecutions. All right, then without giving us opinion, why haven't you yet issued such a directive? Why haven't you required of the Director of Public Prosecutions that they enter into a negotiation? Well, all lawyers here present will easily understand that I cannot, have an impact on this by giving you an answer here and now. I could even say no, but even that would be breaching the litigation privilege. Do you know why your predecessor, the former Attorney General, why didn't she issue such a directive to the Director of Public Prosecutions? Do you know why she didn't? Mr. Fortin, I must now advise you that you are getting very close to the subjudicious issue of your possibly having an impact on the SNC-Lavalin prosecution, so I encourage you to put your question a bit differently. And your 3 minutes have been exceeded.
And to start our path down this study, and I would like to then ask people to suspend for about 5 minutes while we get Mr. Wernick up to the mics. Thank you very much again. Suspended for 5 minutes. We will now reconvene with our second witness group of the day, and we are very lucky to be joined by Mr. Michael Wernick, the Clerk of the Privy Council and Secretary to the Cabinet. Mr. Wernick, it's a pleasure to have you with us, and we'll ask you to make your opening statement now.
Thank you, Mr. Chair. I want to make it clear I came at the very first opportunity that the committee invited me, and that I have always made myself available to parliamentary committees. I've done over 25 appearances. They're all on the record, and I'm happy to try and assist the committee in its important deliberations. A couple of things maybe I could just make as opening comments, and then I'm willing to take any questions, and I'm willing to stay as long as the committee wishes. I have done committee appearances that went into 4 and 5 hours at a time until the committee was satisfied. It's entirely in the hands of the committee. So a couple of things, if I can speak to Canadians through you, Mr. Chair, because a lot has been said and written in the last few weeks, and I think there are a couple of things that need to be clarified. I worry about my country right now. I'm deeply concerned about my country right now, and its politics and where it's headed. I worry about foreign interference in the upcoming election, and we're working hard on that. I worry about the rising tide of incitements to violence when people use terms like treason and traitor in open discourse. Those are the words that lead to assassination. I'm worried that somebody's going to be shot in this country this year during the political campaign. I think it's totally unacceptable that a member of the Parliament of Canada would incite people to drive trucks over people after what happened in Toronto last summer. Totally unacceptable, and I hope that you as parliamentarians are going to condemn that. I worry about the reputations of honorable people who have served their country being besmirched and dragged through the market square. I worry about the trolling from the vomitorium of social media entering the open media arena. Most of all, I worry about people losing faith in the institutions of governance of this country, and that's why these proceedings are so important. So, a couple of things from my perspective. Should Canadians be concerned about the rule of law in this country? No. In the matter of SNC-Lavalin, it is now 7 years since the first police raid on the company, 4 years since charges were laid by the RCMP, and during that entire time and up to today, the independence of the investigative and prosecutorial function has never been compromised. The matter is proceeding to trial. The Director of Public Prosecutions issued a statement, which you can find on her website, on February 12th, in the context of the Norman matter, in which she said, and I quote, "I am confident that our prosecutors in this and every case exercise their discretion independently and free from any political or partisan consideration." That is from the DPP. The only communications with the Director of Public Prosecutions about the potential use of a deferred prosecution agreement, an instrument provided for by legislation, were conducted by the minister, as is appropriate. In this matter, the laws that you as parliamentarians created around ethics in government are demonstrably working. The prosecutor is independent. The Lobbying Act worked as intended. The Ethics Commissioner self-initiated his own process. In other words, the shield's held. The software that is supposed to protect our democracy is working. Is there two-tier justice in Canada? No, demonstrably not. Despite the most extensive government relations effort in modern times, including meetings with officials, political staff, the opposition leaders, paid advertising, advocacy by 2 consecutive premiers of Quebec, the company did not get what it wanted, demonstrably because they're seeking judicial review. Are we soft on corporate crime? No, as you are discussing. Deferred prosecution agreements are an attempt to balance public policy interests. It's a legitimate concern for governments, and indeed for everyone, that the workers, suppliers, pensioners, and communities in which a company operates suffer for the misdeeds of the corporate officers. A deferred prosecution agreement is not an acquittal, an amnesty, an exoneration, a get-out-of-jail-free card, or a slap on the wrist. It is what it says, an agreement to defer prosecution. It is subject to compliance and it can be revoked. DPAs were not slipped into Canadian law. There were consultations leading up to the bill, which drew 370 participants and 75 written submissions before a December 2017 deadline, and I'm sure those submissions would be available to this committee. There was extensive review of the bill provisions at a Senate committee, and that's all on the record. So, I'm open to answer questions about any matter that the committee wants to ask. I think I'm pleased to disclose or discuss my contacts with the company and meetings that took place over the course of the last little while, which have come up in media speculation. I'm here to say to you that the Globe and Mail article contains errors, unfounded speculation, and in some cases is simply defamatory. With that, Mr. Chairman.
Thank you very much. We will now go to our first round of questions, which is 6 minutes each, and we will start with Ms. Raitt.
Thank you very much, Mr. Speaker. Thank you for being here, Clerk. I appreciate it. Were you informed of the September 4 decision by the Director of Public Prosecutions to not proceed with deferred prosecution agreement?
No.
How did it become known to you?
National newspaper advertising.
On what date?
I think the company placed ads in mid-October. I can verify the timeline for
On September
you.
17th, mid-October? Mid-October, national newspaper. I just want to make
Actually,
sure I
if I
got
can
that right.
correct that, I think that I met the company on September 18th.
Yes, you did.
And I don't recall the specific details of whether that decision by the prosecutor had been conveyed to them or not.
So it's possible that you did know on, Mr. Clerk, I'm going to assume that you knew on September 18th that the Director of Public Prosecutions had said to SNC-Lavalin that they were not going to get a deferred prosecution agreement.
I don't know whether that was part of the conversation or not. They came to make the pitch which they made to so many people that they were not the company that had committed the crimes and was being charged, that there had been a change in the board and management of the committee, of the company. They were concerned about the impact on their workers and suppliers, and they did make a pitch for why they were a good candidate for a deferred prosecution agreement.
And they didn't disclose, you don't remember if they disclosed to you that they had been turned down by your own Director of Public Prosecutions?
We have no dealings with the DPP.
And
at the Privy Council
SNC-Lavalin
office.
never made it known to you that they had been turned down. That's what prompted their visit to you on September 18th.
They were making the rounds with everybody in town during that month.
So when they're making the rounds, knowing that as they did, and I think we have to assume that everybody knew who was being visited, because that would make sense why they were setting up these appointments. But knowing that they were coming to ask you to overturn the decision of the Director of Public Prosecutions, at that point in time, you would have known that this would be an extraordinary move by the Attorney General, which can only be accomplished by the Prime Minister.
I remember the conversation being their basic pitch, which they made to everybody, that it was not the company that had committed the crimes, that there was going to be a serious impact on suppliers and workers and communities, and that they were a good candidate for a deferred prosecution agreement. I remember telling them in the firmest possible terms, very bluntly and very directly, that this was a decision for the DPP, and there were powers for the Minister of Justice related to this, and that they should go and make their representations to the DPP through the court process.
Did anybody take notes of that meeting, Mr. Clerk?
I don't know.
Did you have anybody else in the meeting with you?
Yes, the meeting was with Neil Bruce, Eric Ryan, and Sam Boutsievus. I hope I've got his name right, from SNC-Lavalin, and I was accompanied by my Deputy Secretary of Operations, Katrina Tapley.
Is it possible that the Deputy Secretary of Operations took notes?
It's possible,
Would you be willing to have those tabled here?
if they exist.
Would you be willing to undertake to go back and ask for these?
Yes?
At the time of September 17th, Mr. Clerk, the Prime Minister had met with Ms. Wilson-Raybould already, and in that meeting, he had indicated to her that it was her decision. Why would the Minister, why would the Attorney General be in the position of having to make a decision at that point?
It was always going to be her decision, and the decision was it was open through September, October, November, and is still open to the DPP to change her mind and to the minister to exercise the powers on the law.
So we're clearly in agreement then that the decision, the request or the comment that it's hers and hers alone to decide isn't about deciding whether or not to give a deferred prosecution agreement. It's to overturn the Director of Public Prosecutions.
The law overturn would not be the word I choose.
Issue a directive.
There
Issue a
is a
directive.
provision in the statute passed by this Parliament which gives some authorities to the Minister of Justice as ultimately the Chief Prosecutor of Canada to take over the prosecution or to seek the reasons from the prosecutor. I'm not privy to any of the conversations between the DPP and the Minister of Justice.
But you're privy to the conversation with SNC Lavalin, and I have to submit that I find it very strange and indeed odd that SNC Lavalin, knowing as they'd known at that point in time for approximately 13 days that they were not receiving a deferred prosecution agreement, would not mention it to the clerk of the Privy Council, who is the Deputy Minister to the Prime Minister of Canada, and gives advice to the Prime Minister on matters of great importance. And indeed, Mr. Clerk, I would submit it is highly unusual that you would be taking such a meeting with an individual company. You're a very busy executive in the country. I find it surprising that you would have so quickly after they're turned down a meeting with SNC Lavalin and yet not have them tell you that they were rejected by the Director of Public Prosecution. Is that your testimony, that they did not tell you?
I don't know whether they did or not. I can tell you that the company asked for meetings with me several times. I make it a practice to meet with a lot of people who ask for meetings: union leaders, NGO leaders, Indigenous leaders, provincial officials. I meet with a lot of people, and I meet with a lot of company as well. The company is not a pariah. It has not been convicted. It is going to trial.
I'm not saying it was.
Minutes.
Okay, I don't want to leave. I do not want that impression to be on the record that I think there's anything wrong with meeting with SNC Lavalin, and I don't appreciate the clerk indicating that he thinks I'm trying to do so, because I'm not. What I am saying, Mr. Chair, there is a bad inference just let
So we've clarified the inference, and we all understand that that was not your intention?
That not even what I said.
Right.
That's a complete misconstruction of exactly what I said, which was, I'm surprised they didn't tell him.
Okay, that's fine. We're not eating into anybody's time now. We're going to Mr. Boissonneau, 6 minutes. Mr. Boissonneau.
Thank you very much, Mr. Chair. Clerk, thank you very much for joining us today. I would like to start by acknowledging, and correct me if I'm wrong in the numbers, but 37 years of dedication to the federal public service, which spans numerous conservative and liberal governments. And you and I have had an occasion to work together on my LGBTQ responsibilities. My first question for you today, Mr. Warnick, is related to conversations that take place between the Prime Minister or officials in the PMO and ministers. And specifically, I would like to know, is it appropriate for the Prime Minister and officials in PMO to talk to the Minister of Justice and Attorney General about an active case?
The appropriate boundaries of those conversations are exactly the issue of the Shawcross Doctrine, and I would point everybody in the committee to Open Accountable Government, which is the Prime Minister's playbook. There was one from Prime Minister Harper with similar language, and there's one that was issued by the Prime Minister in November 2015. It specifically refers to, in detail, the Prime Minister's view of what's appropriate and not appropriate in terms of dealing with legal matters.
Thank you very much. I appreciate that, according to the book and according to what you've said, that it is appropriate for such conversations to take place and that there are parameters. In your role as clerk, have you ever witnessed inappropriate pressure being applied by the Prime Minister or officials in the Prime Minister's office to the former Minister of Justice and Attorney General on the issue of remediation agreements or any other issue?
No. At every opportunity, verbally and in writing in December, the Prime Minister made it clear that this was the decision for the Minister of Justice to take. She was the decision maker.
Donc, je pense que c'est important de...
So I think it's relevant to ask the question in French. In your role as Clerk of the Privy Council, have you ever seen inappropriate pressure put by the Prime Minister or officials of the Prime Minister's office on the Minister of Justice, the former Minister of Justice and Attorney General of Canada, in this matter of remediation agreements or any other matter. No. The Prime Minister's policy on conversations regarding legal matters is very well laid out in the document that was drawn up right after the elections for an open and responsible government, and this is the policy of the current government in these matters. On every occasion, the Prime Minister has stated, both verbally as well as in a letter addressed to the Minister of Justice, that she was always and always the decision maker. Thank you, Mr. Clerk. And is that the type of letter we could get a copy of, please? Perhaps you could give it to the clerk.
Committee.
Merci bien. Thank you very much for clarifying that no inappropriate pressure was applied to the former Minister of Justice and Attorney General by the Prime Minister or officials in the Prime Minister's office. I think it would help Canadians who haven't seen the book that you referenced, the important playbook, to use your words. How do you, when you're in a conversation, when you're in a room, how do you know where that line is in terms of robust conversations, detailed conversations that do not then cross the Shawcross Doctrine, do not go into direction and pressure?
I think that the minister tried to describe the two hats that he wears, and the committee, I think, will hear from more expert witnesses than I am. I think when you are the Prime Minister and the Chair of Cabinet and answerable before Parliament and go to question period, everything that happens in the government apparatus is of some concern to you or some interest to you to know what's going on and to follow it. That said, each minister has very specific roles given to them by statute to take decisions. There are regulatory decisions and all sorts of things, and there are permits, licenses that are held by the minister. And the role of the Minister of Justice in the case of prosecutions is incredibly clear in Canada. There is a statutory legal force field around the prosecution function in Canada that doesn't exist in the United Kingdom, by the way. We have the strongest protection of independent prosecution that I can think of.
So in the minute and a half that I have left, you said something in your opening remarks that struck a chord with me, was that the rule of law in this country is intact. It's a fundamental principle of our country. Could you give us other examples in your current experience and across your 37 years of experience as to how you make that statement here today?
I have spent time in and around ministers and prime ministers. It's a great honor of my career. I worked very closely with three active prime ministers, former active ministers, a dozen ministers. I've seen cabinet meetings of the Chrétien cabinet, the Mulroney cabinet, the Martin cabinet, the Harper cabinet, and the Trudeau cabinet. And I can tell you about that they are always guided by trying to do the right thing the right way. And the exceptions to that in Canada are extremely rare, are detected and corrected and punished.
Je pense que j'aimerais juste avec les 20 secondes.
I think that given that I have only 20 seconds left, I'll ask you quickly how you're able to say that the rule of law is well respected here in Canada.
Parliament created all kinds of laws to protect ethics in government, and they have been built by successive governments. This is not a partisan comment. Some of them come from different prime ministers in different periods. I'm a big fan of the Accountability Act of Prime Minister Harper, and I'm a big fan of other things that have been done by other governments in terms of adding transparency and being vigilant about ethics in government. As I said, we have an independent prosecutor. The Lobbying Act, which was in the interest of transparency, is working. All of the contacts by the company were disclosed and registered. The Ethics Commissioner, who is an officer of Parliament, created by Parliament to serve parliamentarians and advise parliamentarians, initiated his own process. And my view is that that is the appropriate forum to deal with this. And I am willing to, I've made very clear, as has everybody in this matter, be interviewed and deal with the ethics commissioner, submit to his investigation. He has the powers of a superior court judge to compel production of documents and to get people to act as witnesses. So I commend you to the officer of parliament that you created.
Thank you, sir. Thank you very much. Mr. Rankin.
Well, thank you. And I'd like to say at the outset, Mr. Wernick, to you that you are the 37 years working in all political stripes, and you've been clerk. You are currently clerk of the Privy Council and secretary to the cabinet. You're a servant of the people of Canada, and I thank you, sir, for your service. I have to ask you, there was earlier reference to a letter on December the 5th, a copy of which I think has been alluded to, which is a letter from SNC Lavalin to from the Prime Minister to SNC Lavalin, denying a request for a meeting, but asking that they go see the Minister of Justice. Does it strike you not a little bit odd that that would be the case, given the context?
I don't. If you read the text into the record, I don't think it said go and see the matter.
Obviously, haven't seen it.
It says it's a matter before the courts, and therefore you should deal with the Minister of Justice, which means deal with the legal system through the legal process.
Well, maybe you have time to come back to that. I want to ask you this. And I know you're not going to, not asking you for legal advice, but I'm asking you, given your vast experience, about the nature of solicitor-client privilege in circumstances such as this. I'd like you to tell us a little bit more about your observations.
I've spent a lot of time reading material on the topic of this, the Shawcross Convention and all of these issues and legal doctrines. I'm not a lawyer. I use them a lot, and I'm not in no position to give this committee legal advice. You have excellent law clerks, and you have people that can come and appear. My conclusion, as somebody who spends a lot of time in governance, is I do not see where the former Attorney General was a solicitor. The matter was never discussed at Cabinet, never. So she was not giving advice to Cabinet. She was not advising the Prime Minister. The Prime Minister said at every occasion, verbally and in writing, she was the decider, so she was not giving legal advice to the Prime Minister. She was the decider, the full and final decider. She can't be the fettered solicitor and the battered decider in that horrible, vile cartoon at the same time. It's one or the other.
So therefore, solicitor-client privilege couldn't apply.
That is my conclusion, not my advice.
I'm asking for legal advice. It's your 37 years, a lot of experience. That is fascinating and very helpful. On another related matter, cabinet confidentiality. Is it your view that a person, let's say the clerk, let's say the principal secretary to the Prime Minister, Mr. Butts, meets with the Attorney General at a hotel and talks about a particular matter, that somehow that matter that could be subject to cabinet confidentiality?
There's material on cabinet confidence on the website, and I would commend you to that. It is, and I know this sounds a bit evasive, a bit murky. It generally applies to conversations among ministers, and it generally applies to conversations among ministers about matters before cabinet or about to go to cabinet. But there is law that says that intermediaries and representatives of ministers may be caught in that. I have a statutory role.
Yes, you do.
As the guardian of the confidences of previous governments, and generally as the umpire on cabinet confidence issues.
But can you conceive of how a political staffer could be somehow cloaked with cabinet confidentiality in conversations with an Attorney General?
It certainly could be advice to ministers, and it potentially could be covered by cabinet confidence because those staffers would be representatives of the minister, and the Prime Minister for these purposes is a minister. But I think that that's as far as I think I can go before I'm giving legal advice, which I shouldn't.
You talked in your opening statement, Mr. Wernick, about the Director of Public Prosecutions in this case saying that she wrote that she had freely exercised her and independently exercised her prosecutorial discretion. She didn't budge when asked perhaps to do so, 50 meetings, etc. It appears that the former Attorney General didn't budge either, and then you concluded the system worked. But in fact, Mr. Clerk, is it not possible that we could infer that meetings subsequent to that with the Prime Minister, perhaps applying improper pressure and crossing that red line of the Shawcross Convention, or his chief of staff doing so in a hotel off Parliament, talking about this case after the decision had been made to, as you say, the fully exercised independent discretion of the DPP. Doesn't that strike you that, in fact, the system may not have worked, that there might have been continuing political pressure that Canadians might reasonably infer out of those circumstances?
If you boil it down for Canadians as to what is going on here, with the facts that we have and all of the facts that I know from my participation in meetings and conversations, we are discussing lawful advocacy that the minister take a lawful decision, which in the end she did not take.
Yes. Yes. And then continued political pressure thereafter to change the tune.
So the question that's for the committee, and I would argue for the ethics commissioner as a trained legal professional who is not in any way potentially besmirched as doing it for partisan reasons in an election year before by-elections or running for the leadership of their party. The ethics commissioner was created by Parliament precisely for these ethics and government issues. If this is not the kind of issue an ethics commissioner is there for, why do we have one?
Well, we do, and I think there's a matter before the Ethics Commissioner, as you well know, and it may be that we have a separate responsibility in this Justice Committee to see whether the chief law officer of the Crown, namely the former Attorney General, was somehow improperly interfered with in her constitutionally required independent role in deciding whether prosecutions proceed or not. In other words, we can have different investigations and hearings in respect of different matters. It seems to me completely appropriate. Indeed, we could have a judicial inquiry to determine whether or not, after with
Mr.
full
Reagan,
cross-examination and the like.
So last
I mean, no,
question.
I'm just putting it back to the witness
Yeah, I
that
understand.
doesn't mean
So I'll let
that
the
we can't
witness,
have this
of course,
justice.
I'll let the witness briefly answer, and then we'll move to the next questioner.
I do not see, as a matter of governance, how a separate inquiry overlapping and in parallel with the work of an officer of Parliament with all of those powers would shed any additional light on the matter.
Thank you very much. We will now go to Mr. Assassi.
Thank you, Mr. Chair. First of all, allow me to thank the clerk for appearing before our committee. After having heard your remarks, I think we should all be concerned. One of the things you highlighted was you're very much concerned about media speculation. Now, speaking of media speculation, I'd like to draw your attention to the Globe and Mail article of February 7th, which, as everyone is well aware, is based solely on, it's based on an anonymous source. In that specific article, it is reported that the Honorable Jody Wilson-Raybould's speeches earned her, quote unquote, a private rebuke from the clerk of the Privy Council. Is that correct?
Thank you for the opportunity to put this on the record. That never happened. I can elaborate on that answer if you wish, but that never happened. I have known the former Attorney General for almost 15 years. I was the Deputy Minister at what was then called Indian and Northern Affairs for 8. We walked the path together on many years through many episodes in the journey towards Indigenous reconciliation. I considered her a partner and an ally and a friend, and I would have too much respect for a Minister of the Crown to rebuke someone. That is from an anonymous source about a conversation which would have been between me and the Minister, and I'm telling you it did not happen.
Thank you. Now, you kindly presented us with a letter from the Office of the Prime Minister to the Office of the Attorney General. Mm-hmm. I think some of the members here were implying that there was something wrong with this letter. In your opinion, looking at this letter, reading it, did anything improper happen there?
There was an incoming letter from the company asking for a meeting with the Prime Minister.
Point
the
of
Prime
order.
Minister
I'm sorry,
declined.
Point of order, Mr. Chair.
Sorry?
I'm sorry, just for a
At
second.
the time? Yes, point of
Yeah.
order.
I'm sorry, the member just indicated that members here implicitly indicated that this letter was, I don't know what your word was, but nobody.
I think there was
There's nobody on our side, Mr. Chair, has gone on the record saying anything about this letter. Indeed, we only just received it or even just learned about it.
Exactly. I think what he was referring to was Mr. Rankin, before he had a copy of the letter, asked about something that wasn't in the letter because Mr. Rankin had no copy of it.
Correct.
That's
It's
probably,
an innocent mistake. I really don't like the partisan nature of the comment that was made by the honourable
So
member.
I think you just
appreciate
admitted that a mistake was made, and I simply said it was implied.
Okay.
Would you agree?
I'm going to put Mr. Asasi's time back on, and again, we're all trying to get the answers out of the witness. That's what Canadians want to hear today. So let's get back on to Mr. Asasi's time. Mr. Asasi.
Now, as everyone knows here, you essentially sit on top of the machinery of government. And one of the things that you did say is, first of all, there are many safeguards in our system, but you also indicated that if something improper does take place, it is both detected and corrected. What did you mean by that?
I was alluding to many mechanisms that were created by Parliament to safeguard governance in Canada. I could go through a whole bunch of them. The Public Service Commission is a safeguard of merit-based hiring and staffing in the public service that frees us from patronage. The existence of a parliamentary budget officer, the existence of the Auditor General. There are nearly 14 officers and agents of Parliament holding the executive to account. There are transparency laws, access to information. There's open government policies. I could go on, but I mean, when you compare Canadian governance to that of any other country, I think Canadians should feel assured that they work in a democracy under the rule of law.
Thank you for that. So mechanisms do exist. Now, at some point in your remarks, you did suggest that looking at the structures around the Director of Public Prosecutions, that you think, in relevant terms, compared to other jurisdictions, that we have a really good system in place. Could you elaborate on that? I think it's an important point, and it would be good for all of us to hear your observations.
Well, anybody who is following American politics these days, if you can stand it, will be seeing vigorous debates about the role of prosecutors, grand juries, law enforcement agencies, and so on. And it gets pretty complicated in the American system. And whether pressure was put on prosecutors, whether attorney generals were fired, whether who's doing what in the American system. I think Canadians need to be assured that their police and investigators with the powers of the state operate independently, and that the prosecution service, the state charging people with offenses, are completely independent. And there's a legislative and statutory shield around that, which demonstrably is working in the issue that this committee is looking at. The Director of Public Prosecutors said in writing last week, there is not in this case or any case partisan or political interference in the prosecutorial function. And given that 3 Canadians are languishing in Chinese jails because of arbitrary detention, it's really important to project to the world that Canada operates under the rule of law.
Thank you.
Sassy.
That's fine.
Okay, so now we're going to the second round of questions. This is 6 minutes to the Liberals, 6 to the Conservatives, 6 back to the Liberals, 5 to the Conservatives, 3 to the NDP. And we will start with Ms. Khaled.
Thank you, Chair, and thank you to Mr. Wernick. Your testimony today was very compelling, and we appreciate your public service to this country. And then you mentioned that you've been in public service for over 37 years, and as a clerk, you must have seen, and I think you mentioned this as well, you must have seen multiple governments come and go, and you would have been privy to the way that they conduct business amongst each other as colleagues, as cabinet ministers, as prime minister, and PMO officials. Can you please elaborate on would it be normal practice to have robust discussions both inside cabinet and amongst the prime minister, ministers, the prime minister's officials about what is about the application of both policy and the law in situations that impact Canadians?
I think governments of any stripe are always concerned about the well-being of Canadians and what's going on, and the potential loss of jobs and the impact on families and communities is always of interest. Those could be oil workers in Calgary, to take a topic from this week. It could be auto workers in Oshawa. It could be anywhere in Canada, that no government is indifferent to the economic progress of communities in the country. And job loss is something all governments I've ever worked with worry about and pay attention to and monitor. There is clearly in the SNC-Lavalin matter potential job loss and economic impact on workers, suppliers, pensioners, and communities. This isn't a secret. It's in national newspaper advertising from the company. It is from in the statements of 2 premiers of Quebec. So there are consequences for the decision that to prosecute or not prosecute, to go to a remediation agreement or not. Every decision that a minister makes has consequences for other people. That's the point. The Attorney General is a particularly powerful position in the country because you're the chief law officer and because you have these very specific powers with regard to the role of the state and how it deals with Canadians and Canadian businesses.
And to reiterate, you said that no matter what these discussions are, ultimately the decision is up to the prosecutor and to the Attorney General to make?
Certainly, in the case of the prosecutorial function. I'll take the few seconds to say that I've worked very, very closely for 3 years, almost a daily basis, with the current government, the current cabinet, and the current Prime Minister's office. And in my observation and my experience, they have always conducted themselves to the highest standards of integrity. You may not like their politics or their policies or their tweets, but they have always been guided by trying to do the right thing in their own view, the right way.
Thank you. And you mentioned earlier, you spoke a little bit about remediation agreements as tools. And I'm hoping that you can help us understand a little bit. There's a misconception out there that remediation agreements may be get off scot-free cards, or if you can clarify first, what exactly are they, and how are they a tool? And then I'll ask a follow-up question after that.
Well, I think you had better witnesses just before me to explain the details. My understanding of it is that a deferred prosecution agreement is exactly what it says, that the prosecutor defers going through to trial and conviction in exchange for an agreement. And the agreement is binding, it has compliance tools, it is court supervised, and it can be revoked. It is essentially an alternative sentencing or an alternative punishment deal. Much like when individuals are charged with crimes, there are restorative justice options.
Thank you. And these are these type of tools. Is it normal for the Prime Minister, for ministers, and for the Attorney General to discuss about their use in how they conduct their business?
The statute that created them only came into existence last year. It was debated in Parliament, and it came into force in September of 2018. So
but there are other standards in other countries.
Its potential use, which was advocated by this particular company, would be the first time. So there was a lively discussion about whether this instrument should come to Canada or not, and you'll hear from other witnesses on that. It is a real dilemma from governments should the workers, pensioners, suppliers, and communities pay the price for corporate crime. And I think each of your parties in communicating with Canadians in the election campaign can be very clear with Canadians now whether you think that tool should stay in the box, be repealed, be amended, be improved. But it is an attempt to solve that dilemma that innocent people should not pay for the offenses of corporate officers.
Thank you. Thank you. Just very briefly, I know Madame Drouin earlier, I had asked her about the Shawcross standard and how far does it go in terms of exerting pressure. Can I have your input on that as well? Is it a subjective standard, objective, and then how far does it really go?
I think that any communication or conversation, whether it's verbal, text message, email, can be subject to interpretation as to its purpose, its intent, whether there was subtext, whatever. So I'm not sure it's ever entirely objective. You could read the same transcript and attribute motive or intent or purpose or whatever. I predict that the former Attorney General will express concern to this committee about 3 events. The first is the meeting with the Prime Minister, which I'm happy to describe in detail because I was there for the entire meeting. The second was a conversation between Prime Minister's office staff and her former Chief of Staff when she was Minister of Justice on December the 18th. And the third is a conversation that I had with her in the afternoon of December 19th. How she interprets or perceives those conversations, she can tell you next week. I can tell you, my view very firmly is they are entirely appropriate, lawful, legal, and I'm prepared to submit to the judgment of the Ethics Commissioner on that.
Thank you very much for that.
Thank you very much. Well, that leads into Mr. Cooper, and I'm sure he has some questions. Mr. Cooper.
Thank you, Mr. Chair. Thank you, Mr. Wernick. We have with us the letter of December 6, 2018, wherein the Prime Minister replied to Mr. Bruce, CEO of SNC-Lavalin. Would you also be able to table the letter of October 15, 2008 from Mr. Bruce to the Prime Minister?
I'm pretty sure I can retrieve it from the correspondence.
And I want to ask then about the meeting with the Prime Minister. Can you elaborate on that?
Can I take the committee back to September? The meeting was in September 17th. I'll let you in on a secret, and I'm trying not to be facetious here. The priorities of the government and the Prime Minister in September were NAFTA, 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 and NAFTA. And it was an all-consuming issue for the Prime Minister and for his senior staff. Mr. Butts and Ms. Telford were completely consumed in NAFTA negotiations, which concluded successfully on September 30th, and were not available for a lot of the normal business. I took it on myself with other people in the Prime Minister's office to keep the rest of government files moving so the engine of government would not seize up. One of those files was reconciliation with Indigenous peoples.
I just want to get to the September 17th meeting between Jody Wilson
and I will.
and
The purpose of the meeting, and 90% plus of the conversation, was about the recognition of rights framework.
I want to, in respect to the SNC-Lavalin matter. I don't care about the rest of it. I want to know about the SNC-Lavalin matter.
Yes, and the Prime Minister's characterization of that conversation is entirely the one that I recall.
And what is that? That it was her choice and hers to make?
He indicated that it was entirely her call to make, that she was the decider. And that is a message. That is a message that the Prime Minister conveyed to the Minister on every situation that I'm aware of that it came up.
Even though, Mr. Wernick, the decision had already been made, and then you met again with SNC-Lavalin officials the next day, right?
And I told them the only route. If you let me finish, I told the company the only route they had was through their lawyers and the court process.
And at the meeting was Bill Morneau, is that right?
At my meeting with the company? No.
On September 18th. No. Bill Morneau was not present.
No, as I think I answered in a previous question, I was there with one Privy Council officer person, my Deputy Secretary of Operations, and there were 3 people from the company.
Okay, thank you for that. And you also said that you had many requests from SNC-Lavalin. Had you met with them before in relation to this? Mm-hmm. You had?
I can go through the entire chronology of my contact with SNC if you wish.
Go ahead.
I'm happy to table it with you. There were
No, I've asked you to table it.
No, I want to get this on the record if you don't mind. There were email requests for a meeting in May of 2017, and I didn't take the meeting. There were email requests for a meeting in August of 2017, and I didn't take the meeting. There were email requests for a meeting on September 18th. That's the meeting I took, which is registered. I ran into SNC executives at the NAC Gala. I do remember the evening. Diana Ross was there. They had bought a table at the gala. As soon as I saw that they were there, my wife and I left the event and went home and missed a good dinner. I had a request from...
No, my time is just going to be consumed.
I think it's important to get this
No,
on the
I
record.
I understand. So, Mr. Wernick, what I will give you a chance to do is at the end of the meeting, we'll put that into the record, okay? And we'll make sure that it's there. Mr. Cooper,
Yes,
your time.
at the meeting of September 17th between the Prime Minister and the former Attorney General, did the former Attorney General advise the Prime Minister of the decision of the Director of Public Prosecutions of September 4th not to enter into negotiations with SNC Lavalin?
I think she advised the Prime Minister of her view that a deferred prosecution agreement was not a good course, and she had no intention of intervening. And indeed, she never has intervened.
No, I asked you specifically, did she raise the issue of September 4th, that decision?
I don't recall that came up. It was not that specific. This was a couple of minutes in a long meeting, which was about the recognition of rights framework and an attempt to keep that agenda moving forward. You'll recall the Prime Minister made a speech in Parliament on Valentine's Day last year that he wanted a rights recognition framework announced.
Okay.
We were in September. It was not moving forward. The meeting was called to move forward the rights recognition framework, which was a matter before Cabinet at the time.
Mr. Wernick. And at what point did you learn that the Prime Minister was going to fire Jody Wilson-Raybould, demote her, take her out of Attorney General?
The Minister resigned.
No, I'm asking
About the
you.
shuffle. When was she when did you know she would be shuffled? That's the question for Mr. Cooper.
In January. When I met the Minister on December the 19th, I also had lunch with the Prime Minister and his senior staff on December 19th, which was an end of session wrap up. Oh my goodness, that was a heavy session. And we had a long conversation about planning for January and the Sherbrooke Cabinet Retreat, which took place around the 16th, 17th of January. At that time, on December 19th, there was no thought or talk or any intent to move any minister before the election. It is Minister Bryson's walk in the snow which triggered the cabinet shuffle. It is Minister Bryson leaving and wanting to leave quickly that created the following problem for the Prime Minister. I need a new President of Treasury Board, I need a Nova Scotia minister, and I need to maintain gender balance in my cabinet, solve that problem with the fewest moves possible. And those discussions took place in the first week of January when everybody returned to work.
We'll now go to Mr. Fraser.
Thank you, Mr. Chair. Mr. Wernick, thanks for being here today. I just want to go over the three meetings that you alluded to earlier in your comments. I just want to be clear on the three meetings we're talking about, the nature of those meetings, and who was there and what was discussed. So the first meeting you had mentioned was a meeting that you had that you were present at with the Prime Minister regarding discussions that are relevant to today's appearance. I'm wondering if you could tell us who was at that meeting.
The meeting was attended by the Prime Minister, the Minister, and me, and it was called on the issue of the rights recognition framework and a very serious policy difference between Minister Wilson-Raybould and Minister Bennett and other colleagues about how to move forward. The Prime Minister was quite determined to unblock the file and get it going, and he spoke to the Minister about that issue, and that was almost the entire conversation. The matter did end up going to the new Cabinet Committee on Reconciliation not long afterwards. It went to full Cabinet. There was a decision not to proceed with the rights recognition framework and to focus instead on the languages legislation and the child and family services legislation.
Okay, and the second meeting you mentioned involved PMO staff. When did that meeting happen?
I believe the minister will tell you if there was some conversation between PMO staff and her chief of staff on December the 18th. I was not there, and I'm not aware of the contents of that meeting.
Okay, and the third meeting was the December 19th conversation that you had with Ms. Wilson-Raybould, I take it.
Yes, I initiated a call with her in the afternoon of December 19th to check in on the SNC Lavalin file and other things and getting ready for January. I was calling her as the Minister of Justice. I remember in the sort of thinking about January and what issues were going to come back, and we'd have to move out of the gate quickly because of the return of the House and so on. there were a number of legal files and issues that were coming up. So I checked in with the Minister of Justice on the issue and where it was likely to go and whether a deferred prosecution agreement was still an option. I conveyed to her that a lot of her colleagues and the Prime Minister were quite anxious about what they were hearing and reading in the business press about the future of the company, the options that were being openly discussed in the business press about the company moving or closing. So I can tell you with complete assurance that my view of those conversations is that they were within the boundaries of what's lawful and appropriate. I was informing the Minister of context. She may have another view of the conversation, but that's something that the Ethics Commissioner could sort out.
In that conversation, were you assured or did you have any reason to believe that any inappropriate pressure or direction had been given to Ms. Wilson-Raybould involving this case?
There was no inappropriate pressure put on the Minister at any time.
And she never had indicated any concern about that to you?
Well, I mean, it gives me the opportunity to point out two things. If she felt back in September or October or November or December or at any point that there was inappropriate pressure on her, she had recourse. She could have called the Ethics Commissioner at any time, any day. She could have contacted the Prime Minister at any time, any day. The Prime Minister is available through Switchboard 7 days a week, 24 hours a day, and is working 7 days a week. The Prime Minister is interrupted all the time for calls with foreign leaders, security matters, heads up. So all ministers have the option of reaching the Minister, and give or take a little bit of scheduling and where he might be in private time and so on. Every Minister of the Cabinet can reach the Prime Minister. There were also several Cabinet meetings where people are in the same room and have the opportunity to ask for a pull-aside or a conversation or say, can we step out and talk about this? So there were multiple occasions where the Minister could have expressed concern to the Prime Minister, and every single day could have picked up the phone and called the Ethics Commissioner.
Is it your understanding that the Ethics Commissioner's current investigation into this matter would examine the discussions between the former Attorney General and the Prime Minister and PMO staff?
That is the way his request for document production is framed. It's a request to the Prime Minister, which captures the Prime Minister's office and the Prime Minister's department. So we immediately, as soon as that was initiated by the Ethics Commissioner, started the process of securing documents and ensuring that all the records would be available when the Commissioner got around to asking for them or interviewing people.
Do you know where that stands right now?
I have not heard personally from the Ethics Commissioner, and that's I'm the last thing I'm going to do is interfere in the process. The process is set by the Ethics Commissioner of his own pace and his own volition, and he will exercise it as he sees fit.
Okay, thank you. Those are my questions.
Thank you very much. We will now go to Monsieur Paulus.
Merci, Monsieur le Président.
Thank you, Mr. Chair. And thank you, Mr. Vernick. Mr. Vernick, as Clerk of the Privy Council, you must know that on the 4th of September, when the Director of Public Prosecutions advised SNC-Lavalin that the remediation agreement was not going to go ahead, was the PMO advised?
Vous savez pas à quel moment?
So you don't know when the Prime Minister's office was told? No, I don't. I'm not aware of all communications with the Prime Minister's office, the political officials, but I can check. Could we hear this, Mr. Chair? We would like to know when the Prime Minister's office was advised by the Director of Public Prosecutions. You say that on the 17th of September, during the meeting, that the Cabinet asked Ms. Raybould to appear and you were present, but there was no pressure put upon her with regarding to the SNC matter. That's what you say.
And she would have said something in the intervening 3 months.
Le 10 octobre,
On the 10th of October, SNC published a memorandum to its shareholders saying that so far it wasn't being asked to negotiate a remediation agreement. 5 days later, you say that SNC wrote to the Prime Minister wrote a letter, and I would like to see a copy of that letter, Mr. Chair. So then there was a breathing space between the letter of the 15th of October and the 5th of December. Nothing else. 15th of December, Mr. Butts meets with Jody Wilson-Raybould at the Chateau Laurier. We don't know what was said. Now you're giving us two letters of the 6th of December, the day after the meeting with Mr. Butts. One of the letters informs SNC-Lavalin in response to their 15th of October letter that they must work with Ms. Wilson-Raybould, who is the Attorney General. So between the 15th of October and the 5th or 6th of December, there was no communication. After the meeting with Mr. Butts on the 5th of December, the letter goes out to SNC-Lavalin. And at the same time, the Prime Minister, Mr. Trudeau, writes to Ms. Wilson-Raybould that he received a letter on the 15th of October and that she should see to it. So on the 5th of December, we had this meeting, and the next morning, two letters go out. Is that correct? There is no connection between these two matters. There is a letter that was received by the Director of Correspondence, and this was from the company requesting a meeting. It took a good deal of time to draw up a response and to have it signed, and that is quite normal. There was no communication with the cabinet. It was routine correspondence. In your opening statements, you said very clearly that you have a specific view of the rule of law, and you shared that with us. And you say that, that's why we at the committee are meeting and we're working hard to shed light on what may have occurred. You are sometimes present at meetings with the Prime Minister, but not always. You're not always there when the Prime Minister meets his ministers. True. So it is possible that the lines were blurred and that you weren't there. That's a hypothetical question. But is it possible that there was pressure put on someone and that you simply wouldn't have been aware of it? You're not aware of everything that goes on in all the offices and all meetings. If there had been another meeting or conversation between the Prime Minister and the Minister will be in a position to confirm that to you next week.
Mr. Clerk, you said in your view that there's no solicitor-client privilege engaged. Who advised the Prime Minister that there is?
There wouldn't have been a formal legal opinion from the Privy Council office. I don't know the answer to that.
Okay, so neither the PCO nor the Attorney General have given him any advice on it.
I think it's actually the former minister who was the first to say that there were matters of solicitor-client privilege, if you check the chronology.
Okay. At any point, has a memorandum to Cabinet or a ministerial recommendation been brought forward to direct, instruct, encourage, or otherwise influence the Attorney General to create the conditions where SNC-Lavalin would receive a deferred prosecution agreement?
No.
And as you may be aware, Mr. Cooper at this committee did request the production of documents, and that was not approved by the committee. But what I'd like to ask you now is, would you be prepared to commit to provide all records in your possession on both personal and government devices?
Mr. Barry, just need to advise that only matters discussed in camera, only matters that are adopted are public.
Is that not in camera?
Okay, so I'm just that's why I'm the chair and I'm advising. So
the motion was public. The motion was public.
But again, again, you could have said Mr. Cooper put on notice a motion saying that. But in any case, I'll let you finish your question. I'll let the witness answer, but just to point out for the future that's.
Yes, thank you, Mr. Chair. Would you be prepared to commit to provide all records in your possession on both personal and government devices relating to the prosecution of SNC-Lavalin, any communication between the Office of the Minister of Justice and Attorney General, Department of Justice Canada, the Public Prosecution Service of Canada, the Prime Minister's Office, and the Privy Council Office?
I'd have to respectfully decline. Those requests have been made by the Officer of Parliament who works for you, and I will comply fully with the request for production of documents from the Ethics Commissioner.
But can committee members not request papers?
Yeah.
So again, you can request them. He has declined that. The committee can have votes to ask for those documents if a motion is properly put. So again, we've now exhausted those questions, and we're going to move to Mr. Rankin. Mr. Rankin.
Juste pour confirmer, au début, est-ce que vous pouvez confirmer?
But at the outset, could you confirm to me that Mr. Fortin will have a chance to, we'll ask for time for you at the end of your time. It's a matter for the committee to decide, not up to me. But if necessary, I'm willing to share my time.
Is the committee in agreement to give Mr. Fortin 3 minutes again for this witness?
Yes.
Okay.
Thank you.
So then, Mr. Rankin, you have 3 minutes.
Voilà, merci. Mr. Clerk, you said that, and I quote you in answer to a question from a Liberal, there's, quote, no inappropriate pressure on the minister at any time. And however, you did acknowledge that that her experience might not have been what you experienced in a particular meeting or others, and you surely must acknowledge that she could have had meetings out of your earshot at a different time in a different place with ministers, indeed the Prime Minister, and perhaps had meetings with people in the Prime Minister's office who she might have felt inappropriately pressured her. So to say that she had no inappropriate pressure at any time is really a conclusion you're not able to draw.
It is my conclusion and my assertion, based on all the information that I have, that there was no inappropriate pressure on the Minister of Justice in this matter.
And you just acknowledged, though, that you can't speak to her experience. She is anxious to speak her truth. She's told us as Canadians she wants to do so, and doctrines like solicitor-client privilege have been evoked, which, with great respect, you've indicated may not even apply here. I think we need to hear from her rather than, with great respect, you telling her what you think she experienced.
Well, I think the matter may come down to the Ethics Commissioner's view on a conversation between two people, between what was sent and what was received. And I think the Ethics Commissioner is the appropriate person to decide what was undue and what was inappropriate.
If she never got directed, she certainly got fired. Those are the facts. Oh, I'm sorry, removed. Those are the facts. So how can you not acknowledge that she might have felt a tad of pressure in those circumstances?
During the time she was Minister of Justice, she did not exercise the option of a deferred prosecution agreement, and she was not fired. She was offered another position in cabinet because the shuffle came up in early January, and she accepted it. There were conversations between the Prime Minister and the Minister over the course of that week. I believe the dates would be something like January 6th and 7th. I'm not party to those. Those are between the Prime Minister and the former minister. She had every opportunity in those conversations to indicate that she had felt any pressure. She could have at any time after my conversation of December 19th picked up the phone and called the Ethics Commissioner, could have picked up the phone and called the Prime Minister. She had conversations with the Prime Minister about accepting a new responsibility in cabinet, which I frankly don't see as a demotion.
I didn't use that word. I said removed. She was fired from her role as Attorney General.
She was
removed from that role,
and
then she took another position, and then she
my
quit the
view
cabinet.
on it is
Those are the
that
facts.
the fact is she was offered another seat at the table in cabinet, which is a privilege that 1% of 1% of 1% of Canadians have.
Maybe she didn't feel that way.
Then she could have declined the offer of the seat.
And she did subsequently.
We're at 3 minutes. Monsieur Fortin?
Merci, Monsieur le Président.
Thank you, Mr. Chair. Mr. Warnick, hello. Could you tell me whether, prior to giving testimony here this morning, have you discussed what you would be saying with any members of the committee? No. Never. None of us has had any discussions with you before you came and sat here before us to speak to us. No. No, I think I was introduced back here having coffee, but I have not discussed my testimony with anyone here, with the exception of an attorney of the Minister of Department of Justice. Are you aware of the reasons for which the former Minister of Justice was shuffled to
I don't think this is a big secret. The resignation of Scott Bryson created a vacancy at Treasury Board. And the problem that was presented to the Prime Minister is to replace the Treasury Board President, maintain a Nova Scotia person in cabinet, and maintain gender balance. And those were the deliberations that took place in the first week of January.
Thank you. Est-ce que vous avez
Have you spoken with Ms. Wilson-Raybould? Have you spoken with her since she was shuffled to Veterans Affairs Canada? Did you discuss her being shuffled? I was present at the swearing-in ceremony. That's me in the photograph, where she is being sworn in. This was not brought up then. She came to the minister's retreat in Sherbrooke. That lasted 3 days. She did not bring anything up, either with myself or with the Prime Minister. At no time after she was moved, and she met with us in 2 other meetings of the Cabinet and didn't bring anything up. You had no discussion with her on these topics, though, as you say yourself. No. But you say that you worked closely with her, 8 years, you say? I can't remember exactly what your role was, but before she became a minister? Yes, I've known her for about 13 years. And at no time after she was put in charge of the Veterans Affairs Canada did she speak to you. Speak of what? Speak of her being shuffled from the position of Minister of Justice to that of Minister of Veterans Affairs. No, I think the only communication was a letter that she sent to her former employees when she was Minister of Justice. A last question, Mr. Warnick. Are you aware of any discussions between the Prime Minister's office and the Government of Quebec concerning any potential remediation agreements that might be negotiated with SNC-Lavalin? No. No knowledge. So to your knowledge, there were no discussions between the Prime Minister's office, their officials, and representatives of the Premier of Quebec on these matters? I don't know. Well, I have no knowledge of such conversations, at least between political advisors of the various levels of government. Your time is out. Thank you very much.
7 years of service to
Point of order?
Canadians. Yes?
Thank you very much, Mr. Chair. I know that at the beginning, Mr. Warnick was very generous in indicating that he'd be happy to stay here as long as we needed in order to get to the bottom of matters. Obviously, we have more questions on the opposition side, and I'd like to move the motion that we invite Mr. Warnick to stay for another hour with us.
Second.
So, one second, please. The motion to proceed. Because it's 1:25.
I think an hour is good because we can all get our rounds in again. So that was the time that I picked. Yes.
No, just because you're going into question period. If yeah. So wait, is the motion debatable? Yes. Okay. So this is a debatable motion.
Okay.
Yeah, but I just want to that's your intention to go to 2:25 because it's 1:25 now.
Well, I'm happy if there's a. Let's see how the conversation goes. If there's a negotiation on going to 2:15, I'd be willing to talk about 2:15.
Okay. I understand. Mr. Fraser.
So obviously, a motion was passed for the witness list that included a motion regarding how the witness testimony would go, and it was to be for 1 hour, and it's been understood that it would be with 2 rounds of questions. That time has exhausted. I believe that's consistent with other motions that have been brought forward, and so I think that is the end of the meeting. Thank you.
Okay. So there's a motion, so you have to defeat the motion. Any other discussion on that motion?
Let's call the question.
Okay. So I'll. Of course. So we will.
Is it possible to call a point of order on a vote, Mr. Clerk?
Yes. So is it possible to call a point of order?
The motion was moved on a point of order. Is that possible?
I agree. You cannot normally move a motion on a point of order, but she did have the floor, and she could have put forward the motion without saying point of order when I recognized her. So, I think that either way, it's fine to have the motion because it could have come forward in any point. If she hadn't said point of order, I still would have recognized Ms. Reid out of courtesy. So, that being said, let's call the vote. Mr. Clerk?
Suspend, Mr. Chair.
Oh, sure.
5 minutes.
Of course. Why don't we? If there's a conversation to be had, let's suspend shortly before the vote. Folks, sorry, I didn't give you your 1 minute this time, mais on va recommencer. Je crois.
We will start out again and run the clock. I think there's an agreement between the parties that we will go for another round of many minutes, 24, and 6 minutes to each party.
First round of 6 minutes on each side 4 times. And I think that's an agreement, so we don't need we'll just agree that the motion is amended for that and unanimous consent to do that. Thank you, everybody, for your cooperation. And this is, for you folks, the normal collegiality we do have at the Justice Committee on most matters. This is a 6-minute round. The Conservatives start. So who's going? Ms. Raitt.
Mr. Waring, at the beginning, in one of our in one of our segments of questioning, you had indicated you had a chronology. I'd be very interested in hearing your chronology now into the record. I know we said that we would give you an opportunity to do so. For me, the most interesting pieces that you've given us information on today are those 3 meetings that my friend from across the way did ask you about earlier. But if you can put it in context for us, starting from around, I guess, the middle of the summer of 2018, either conversations you had with the Prime Minister or Ms. Wilson-Raybould, or conversations you had with SNC-Lavalin. If you just give us a chronology, if you may, in as best way you can, that would be extremely helpful.
So one piece that might be relevant to you is, where did deferred prosecution agreements come from? They don't come into Canadian law through immaculate conception. They come as government bills because there was a cabinet discussion. There was a cabinet discussion in the spring. I would have the dates. Amendments aren't made to the criminal code by any minister other than the Minister of Justice. So the former Minister of Justice and the minister responsible for procurement obviously were the ones who proposed DPAs and sponsored the legislation. And that is a conversation in which SNC would have come up as background and context for the kind of companies and offenses for which DPAs were relevant. There was never a cabinet conversation about the prosecution.
Right.
Okay?
Yeah, thank
you.
you.
I hope that's helpful.
Yeah.
I do want to clarify, because I think I'm worried about reputations. I want to be very clear, at the risk of opening the cloak a little bit, that when the former minister addressed cabinet earlier this week, the current Attorney General left the room, saw it right away, the need to recuse, left the room, and was not present for that discussion.
That's very helpful.
Okay. That doesn't mean I'm going to tell you the whole conversation inside the room.
I don't want to know.
I think it's important to know.
That is important
the
to me to know.
Canadians need to know that the current Attorney General left the room for that conversation to relieve himself of any responsibilities of what do I do with that information.
Right.
Okay.
It's too bad.
So I'm trying to reconstruct. The summer was all NAFTA.
Yeah.
There was a cabinet retreat at the end of the summer in Nanaimo. I remember the smoke and the fires, as I'm sure you do, Mr. There were, I'm not trying to be facetious, there was a lot being prepared for the fall session, a lot of balls in the air. I did not discuss the SNC matter with anyone that I can recall, frankly. It was in the hands of the Prosecution Service and the Department of Justice.
Great.
Once there was a parliamentary process underway, by that time I think the Budget Implementation Act had passed the House rather rapidly, if you remember, but it was before the Senate, and there were Senate hearings. And I probably have transcripts or summaries of the discussion of the bill, because I get them for most bills, and just I track the progress as does my office, of legislation that moves through the 2 chambers of Parliament. The preoccupation where I would have had any interaction with the former minister was around the rights recognition framework, the Indigenous agenda. There's a different story arc there, which I'll try to reconstruct. The Prime Minister is unwavering and relentless in his commitment to moving forward Indigenous reconciliation, and very impatient, as Prime Ministers are, to get things done and get things moving. And he was concerned that we were losing momentum and traction heading into the last year of the mandate on the rights recognition framework. He was aware, because he'd been briefed both by the Privy Council Office and his political staff, that there was something of a policy standoff among his ministers. There were different views on a very significant thing. And we were trying to find a way, essentially I'd call it a form of conciliation or mediation, to bring people together. You have some experience in the matter. Ministers can have very different views, quite legitimately, about how best to proceed, and Cabinet's there to sort these out. So given that there was so much time being sucked into the NAFTA thing, I was asked to step in and play a bit of a role in bringing together the different views. I do want to say on the record for Canadians that I am deeply hurt on behalf of Minister Bennett that her reputation has been trolled over the last little while. There are vile things being said in social media about her in the wake of Minister Wilson-Raybauld's resignation. I worked in the area for most of my career, and I want to say on the record, there is no Canadian who has worked harder on Indigenous reconciliation than the Honourable Carolyn Bennett, and she deserves better from the social media trolls. Now, there was a legitimate argument within Cabinet about how to move forward on the rights recognition framework, and there are discussions that would have taken place on the right approach to child and family services legislation, which I truly hope you're going to see soon in Parliament, the languages legislation, other Indigenous matters. Minister Wilson-Raybould played a very particular role in Cabinet. She did not ever want to be one of the Indigenous Affairs ministers. She made that very clear. She did not want to be the Indigenous Services Minister or the CERNA minister and be seen as the Indian agent for her own people, and that's the way she's made that clear in public. But as Minister of Justice,
we're at 6 minutes already. I'll give you another minute to try to wrap up your answer to Ms. Raid's question.
I will wrap it up quickly in the sense, but she was deeply involved as Minister of Justice, because these are matters of law, on how the rights framework and all the Indigenous things would, and of course she had enormous power and influence because of her background and where she came from. And so we had a
meeting on the 17th.
The purpose of the meeting, why it was called, was the Prime Minister wanted to get momentum and traction back on the Indigenous agenda.
Thank you very much. Mr. Boissonnault.
Thank you very much, Chair, and thank you, Mr. Wernick, for your offer to spend more time with us today. I was struck, and I know you to be a direct man, and I was struck by your opening remarks. I'm wondering if, and I think, I know I do, I share some of your fears about interference in the political process, about the state of democracy, and I'm wondering if you could elaborate a little bit more on how strong governance can help mitigate against some of the fears you mentioned in your opening statement.
That's a big topic, and I don't want to run out the clock on it. I have spoken about matters of Canadian governance probably 20, 30, 40 times, and all of those speeches are on my website. So for those watching, clerk.gc.ca, and I've talked a lot about governance in Canada. I do think it's important that Canadians, the 36 million Canadians, understand, and this is a precious thing, and I've said this publicly, when you see what's happening in London, in Washington, in Paris, in Rome, in other democracies, never mind other countries that I will not name, who are clearly more authoritarian, we should take comfort that we have independent police and prosecutorial services, that we have courts, that we have officers of Parliament assisting the people that are elected in free and fair elections to guide the country. It's a precious gift, and it is under threat around the world, and I don't take it for granted in Canada, and there's many, many ways we could pursue that conversation. The one that's relevant to this committee, and I know that you want to be on the Justice Committee because you share these concerns about the rule of law in Canada, is the independence of the prosecution service is one of the cornerstones of that.
I'm glad you mentioned that, because one of the things you mentioned in one of the responses was the safeguards that we have in place. And you mentioned the Public Service Agency of Canada, the Parliamentary Budget Office, access to information, open government. Could you share with us and with Canadians some of the other safeguards? I think you mentioned a list of some 14 or 16. What are some other examples?
Well, it's a sort of watchdogs and transparency, and a vigorous Parliament holding the executive to account. You're at risk. I'll try to keep this short. I occupy a position that has existed for almost 800 years. The King's counselors and advisors. That is exactly what the Privy Council oath is, to be a true and faithful advisor to Her Majesty. Some of you got to take that oath. Some of you aspire to. It's important. Those are the 30 to 40 men and women who get to take decisions as a group in cabinet. And it's everything that's wrapped around that and their accountability to the legislature. That's the basic Westminster software of the country. It's not a book club thing. It's not theory. It's fundamental to how we govern ourselves as a free and democratic people. So, I mean, there's many topics in there. I think it's important because when you get these episodes of high octane politics, and they do happen and they're legitimate, and I want to be very clear, partisan politics in a democracy is entirely appropriate. You should go at each other hammer and tongs to convince Canadians to send you back here. But when that debate starts to cause Canadians to lose faith in their institutions, I worry that we're on the slippery slope to what we see south of the border.
So you mentioned the United Kingdom, and 5 times later, maybe I'll ask you the question about what the safeguards that we have that the United Kingdom doesn't have, and how that may be causing things to play out there. But I am interested because you mentioned the King's Council, and you mentioned the 800 years of history, and you mentioned the impartial nature of the Privy Council office. Can you just share with us and with Canadians what structures, governance, safeguards are in place to make sure that the Privy Council office is impartial and independent?
I commend anybody who's really interested in the topic to Open and Accountable Government, which is on the website, by the way. This is an old analog paper copy of a digital document. I just like to have it with me. I mean, the Privy Council office is the Prime Minister. I wear 3 hats. Minister Lametti wears 2, I wear 3. So one is I am the Deputy Minister to the Prime Minister, and I run a department of 900 souls who support the functions of the Prime Minister. And you're familiar with many of them, to make sure that with all the jobs that the Prime Minister has, and he probably has 6 or 7 hats, they're well supported. And I'm a Deputy Minister like any Deputy Minister. I also am the Secretary to Cabinet, and that's the role that you would have seen in any Tudor-era movie of somebody taking notes while the King's Council met. And part of that is to support and record the business of Cabinet and to protect the confidence of those conversations. And Cabinet only works when those conversations are kept confidential. So Cabinet confidence is a really, really important thing. Otherwise, those men and women would not feel free to express themselves, to argue, to disagree, and you would not get the best possible outcomes for Canadians. So I am institutionally the guardian of Cabinet confidence. I get to rule on disclosure of documents. I protect the confidences of all previous governments so that you don't demand with your majority on the committee the discussions that took place in the Harper government. The Harper government didn't demand all the discussions of the Martin government, right, and so on. You know you can speak freely in the Cabinet room because it goes in the vault, literally in the vault of confidences. There are situations where they should be disclosed. I know that some of you follow the Norman trial very closely. I made a decision of my own volition, with my own authority, that the easiest way to deal with the Norman matter was to let the judge decide what was relevant. And I did that last October. That is an exception and an anomaly, but that's an example of our role. I have a very statutory role under the Evidence Act with regard to Cabinet.
Thank you very much. I suspect you'll see the website traffic tick up today.
Thank you. More people interested in PCO than ever before. Thank you very much, Mr. Rankin.
And thank you, Mr. Wernick, for referring to what you called, I think, properly the precious gift of an independent prosecutorial service. We had a final decision by that prosecutorial service. That was September the 4th. And then on September the 17th, at a meeting that you've told us was primarily about Indigenous issues, the Prime Minister and the Minister talked about SNC-Lavalin. And then on December the 5th, there was a meeting with Jerry Butts and the former Attorney General as well. That we know. Now, during that period, there were literally dozens of meetings that you've told us about some of them, SNC-Lavalin had with people in the Prime Minister's office and the like. So my question is, with all of that repeated lobbying by of the Prime Minister's senior staff, its only purpose could have been to go over the Attorney General's head and to get influence the decision that she'd previously refused to make, that the company had asked her to make. So this is what Andrew Roman, a prominent Toronto lawyer, concluded. Quote, there was no valid reason for either the Prime Minister or his senior staff to have initiated such a conversation with Jody Wilson-Raybould. The only reason for either of them to discuss her prosecutorial decision would be to encourage her to change it without being seen to do so. This is damaging to the rule of law. What do you say?
I don't agree with that. I don't agree with the premise or the conclusion.
Can you elaborate why?
Because there are appropriate conversations to have with the Attorney General in this kind of matter, and that is exactly the Shawcross line. And I think you will have to come to a view as to whether the Shawcross line was crossed or not.
I personally agree entirely with your conclusion. That is, there is a line, and it's inappropriate to direct, we've heard, and that's why we first had the Prime Minister using that very careful lawyer language. And it's also inappropriate to pressure. And you've said that you didn't think there was any pressure. It would appear to most people that our former Attorney General certainly felt that pressure coming from someone. And it may not have been the Prime Minister, but it could have been. Often people get others to do that. And that could properly have been people in the PMO with whom SNC Lavalin met dozens of times. Is that not, don't the dots connect, or at least can't they reasonably infer that they connect in that fashion?
The question that I think you're going to have to come to a view with, as will the Ethics Commissioner, is inappropriate pressure.
Right.
There's pressure to get it right on every decision, to approve, to not approve, to act, to not act. I am quite sure the minister felt pressure to get it right. And there were, part of my conversation with her on December 19th was conveying context that there were a lot of people worried about what would happen, the consequences, not for her, the consequences for the workers and the communities and the suppliers.
How can she, why would she have said in her letter to Canadians, this unprecedented letter when she was removed as Attorney General, the need to have an independent Attorney General function, and then make similar comments just this last couple of days? How can I but infer that she must have felt that pressure, inappropriate pressure, over the line Shawcross principle pressure? How can we infer anything else from that?
I think you should ask her directly.
We intend to, if we're allowed to have her speak her truth, and we're not yet, after hearing the Attorney General today, confident that's going to be allowed.
It will be up to the minister how she chooses to respond to your questions.
Subject, she says, to solicitor-client privilege, which you said may not even apply.
As she sees it.
As she sees it, yeah. If she's allowed to speak.
It's not a question of being allowed to speak or waiving any confidences. She can come here next week and answer your questions with her sense of where to draw the line on the answers.
Thank you, Mr. Rankin. Mr. Fraser?
Yeah, thanks, Mr. Chair. Earlier in your, I believe it was your opening statement, it may have been in an answer to one of the questions, you talked about the positive, and I believe you used the word ethical dealings that you'd had with the current government, Prime Minister, and officials. How did you come to that conclusion, and could you tell us how it may relate to why we're here today?
Close observation, and I spent a lot of time with them every day for 3 years, and a lot of interactions. I run the Prime Minister's department. I deal with the Prime Minister's political staff virtually every day, and I have done for 3 years. I know a lot of them. I spent a lot of time with them. I've traveled with them. I've met with them. They become the environment. I'm not making a partisan comment because I work with the Harper PMO and the Martin PMO and the Chrétien PMO, and I think Canadians should feel comforted that the people that come into and make enormous sacrifices to be political staffers and enter political offices are always trying to do the right thing the right way. There are exceptions. We all know the exceptions, but they get caught. They get caught in Canada.
Just switching gears a little bit, earlier in your testimony you indicated that the work of the Ethics Commissioner and his ongoing investigation should be respected and obviously allowed to get its work done. Some have come to the conclusion that only a public inquiry in this matter would actually get to the facts of what happened. I'm wondering what your comment about a public inquiry would be.
I mean, that's ultimately for other people to decide. My advice would be I don't see how it's an upgrade. You have an officer of parliament with superior court powers. You have a methodology. You have a track record. You have the training. There's not the slightest possibility of partiality or bias. It's the instrument you chose to create as an officer of parliament to deal with ethics issues. So, and its simplest version, why do you need another instrument?
And in your view, it will get to the essential questions that are being asked in this matter?
I've watched public inquiries, we all have over the last while. They have their utility. They absolutely have their utility. But they Gomery, I mean, there's many, right? And PCO actually provides the funding and the administrative support for inquiries. They have a particular character. They get lawyered up. They are adversarial. They're not always the right way to get to the bottom of something. This is a relatively simple matter in its essence. If you strip away all of the hyperbole and the rhetoric, it's about whether a minister felt inappropriate pressure. And that can be traced to specific conversations and meetings. And I think that the ethics commissioner could get to the bottom of this fairly quickly.
Thanks, Mr. Warnick.
Thank you. Mr. McKinnon, there's 3 minutes left, so Mr. McKinnon,
Yeah, just a quick question. I know my opposition colleagues across the way have expressed considerable concern that once the DPP decision was made on September 4th, that any further address to the AG in that matter was in and of itself inappropriate. I'd like your comments on that. In the context, as I understand that the DPP Act itself provides for that kind of follow-up and that kind of override. And my second question pertains to lobbying efforts by SNC-Lavalin, which you indicated earlier were perfectly lawful and not untoward at all. So I wonder if you could further address that as well.
Maybe the second point. I mean, I think that it's not a small thing that all the contacts between the company and various people were disclosed. It means that the basic structures of the Lobbyist Act, which were brought in response to other issues years ago, seem to be working. You can reach your own conclusions about that, and laws can always be improved, but the basic structures of the Lobbyist Act in terms of transparency seem to be working. I'm going to get somebody in the company in trouble, but what Canadians need to know is that despite a massive government relations effort, meetings with MPs, staffers, leaders of the opposition, paid advertising, pressure put through 2 premiers of Quebec, they didn't get what they wanted. If it's a movie, it's a flop.
McKinnon's first question, whether it was inappropriate to have any discussions following that first date of September the 4th, or when the PMO became aware.
That's a question I think probably requires legal advice from the clerk and the law clerks or from experts. My interpretation of it and the basis on which I have conducted all of the conversations is that it wouldn't be that the same basic principles and rules would apply even after that point, because the minister always had and even still has the option of invoking those powers. It's the same Shawcross frame whether you're early in the process, late in the process, or even today.
Thank you so much. So, colleagues, that exhausts the following round of questions. I want to thank you, Mr. Warnick. Thank you for your service to Canadians, and thank you for all you did. I think your testimony helped us a great deal, and meeting adjourned.